Yes, sir. Yes.
Yes, yes, yes.
So now we will be discussing about laws of real estate. As Sandeep ji have told you, this is very important topic, though it is in the syllabus of land and building valuers, but it is equally important for all the valuers of all category, as on some time you may have to face the various things related to this topic. In this topic, you have to learn about the Land Acquisition Act, the act which has been promulgated for land acquisition, which have to be acquired by the government for infrastructure purposes. That is LARAR, Land Acquisition, Rehabilitation and Resettlement Act 2013. Then we have to study about the general building rules and regulations. As an engineer and as an architect, you all know the building bylaws of your state, and for more on this topic, you may refer National Building Code 2016. And then you have to learn about the rent control laws. Rent control laws are state subject. Every state has its own rent control act, and which have been recently amended by various states and has been renamed as modern rent control act laws, in which you have to study sections pertaining to occupancy rights of tenant, freezing of rent, protection against eviction of tenant, and its effect on value of the property. As we have in the case studies, we have learned about the effect of rent control on the value of the property. Then we have to study right of way and section 52 licenses under the Indian Easement Act 1882. Then we have to study salient features of real estate regulation and development act 2016. Basically it is RERA, which all you know, RERA act, which is for regulating the construction. Then the most important thing, which is very important for all of us, that is transfer of property act 1882, which is related to transfer of immovable property, sale, mortgage, gift, exchange, assignment, charge, lien, tenancy, subtenancies, lease of immovable property, lease granted by private and statutory bodies, impact of each on the valuation. Then you have to study section 3, 5, 6, 7, 25, 53, and 53A of the Transfer of Property Act 1882. And in the end, we have to study laws relating to inheritance, succession, Mohammedan Muslim Personal Law, Hindu Succession Act 1956, Hindu Succession Amendment Act 2005, the Indian Succession Act 1925, Law of Succession for persons other than Hindus and Mohammedans. And then we have to learn in the end will and testament. So it has a huge weightage of 7%, 7 to 8 questions you will be getting out of this topic, which is most important for values of law, land and building, but it is equally important for all the values. So first of all, we will learn and discuss Land Acquisition Act, LARAR 2013. So first of all, you must understand for what purpose this law is. It is for right and fair compensation and transparency in land acquisition. So right to fair compensation and transparency in land acquisition. Especially as you know, lands are acquired by mostly they are acquired by the government for infrastructural purposes. And many times there are disputes about the fair compensation. And that is why this law has been amended and renamed as Land Acquisition, Rehabilitation and Resettlement Act 2013. First, we will discuss about its key features. First and the most foremost thing which has been included in this act, in the amended act, is fair compensation. Fair compensation means this act ensures land owners receive fair on compensation for their land. Means the land which is acquired by the government, the owner of the land gets fair compensation. For example, if a farmer's land is acquired for a highway project, they are entitled to receive compensation based on market value of the land, plus additional benefits are also given. Not only the market value of the land, certain other benefits are also given, which we will discuss in the coming slides. And then the most important thing is transparency. The process has been made transparent. The process of land acquisition must be transparent with clear communication and documentation. For example, public hearing and social impactment assessment are mandatory to ensure that affected parties are informed and can voice their concerns. So in the amended act, these things have been included. The most important thing is social impactment assessment. Whenever a project is to be started by the government and land has to be acquired for that purposes, a social impact assessment of the project is done by the competent authorities, which was not there in the old act. And another thing is that every person, every owner has a right to be heard. The competent authority have to hear his grievances. So public hearing is most important factors in this new amended act. And next, social impact assessment. So, for example, before acquiring land for a new airport, at SAI means social impact assessment is conducted to evaluate the impact on local communities, including loss of livelihood and displacement. So, why this social impact assessment is done? This is done to help in planning appropriate mitigation measures. So social impact assessment is done so that appropriate mitigation measures are taken or planned. And the important thing is consent and transparency. This is the important thing. This was not in the old act. This has been incorporated in the new amended act, that private project consent of 80% affected families is required. So you have to remember this thing. Many times you may get 1 mark question over it. You have to remember that in case of private projects, 80% of the affected families should give their consent that they are ready to give their land if it is a private project. And if it is a public project or a public private project, then consent of 70% landowners is required. And of course, public hearings are mandatory to discuss project details and address the concern of all the affected families. So this thing is most important, and many times in IBBI examination, you may get 1 mark question out of it. And then the most important thing which has been incorporated in this amended act is rehabilitation and resettlement, which was not there in the old act. So it provides rehabilitation and resettlement of all the affected families so that post acquisition social and economic status of the affected families is improved. For example, families displaced by a dam project may receive new housing, employment opportunities, and other supports to help them rebuild their lives. Then provision for land to land compensation. So another thing which has been incorporated is that there may be land to land for land compensation instead of monetary compensation for land. That the affected families may be given land at certain other location, similar location, if they agreed for that. So instead of monetary compensation, affected families can opt for alternative agricultural land of equal value, ensuring their livelihood continues. Then regulating authorities. Who are the regulatory authorities to implement this land acquisition, rehabilitation, and resettlement act? So first one is LARR authority, Land Acquisition, Rehabilitation and Resettlement Authority, which is called LARR authority. So it is established in each state to ensure and oversee land acquisition process in a particular states, which ensure that all the laws and bylaws of this act are implemented in the state by the concerned authorities. For example, Maharashtra LAR authority ensure that all land acquisitions in the state follow regulations set forth in the act. And over that, there is another authority, National Monitoring Committee for Rehabilitation and Resettlement. It is abbreviated as NMCRR, National Monitoring Committee for Rehabilitation and Resettlement. So it monitors the implementation of R&R policies of the states and ensures that affected families receive benefits they are entitled. For example, NMCRR reviews reports from state authorities and make recommendations to improve R&R process. Next, we will discuss about the general building rules and regulations in India. For that, you can refer to building bylaws of your state, or for better understanding, you may refer to National Building Code 2016 or Modern Building Bylaws 2016. So all the state bylaws are based upon National Building Code 2000. So it's related to structural stability, fire safety, and other components of the buildings, as well as it also give details about the method of getting your proposed plan approved from the competent authority. So first thing it deals with is the structural stability. So what is structural stability basically? So it ensures that buildings are structurally sound and can withstand various loads and forces. So whenever you design a building, you plan a building, the first and foremost thing you have to decide about the expected nature of forces to which it will be subjected to. Expected forces to which this building will be subjected to. Then you will calculate their magnitude. From their magnitude, you will calculate the actions they may cause, bending moment, shear force, and other things. And then based upon these things, you will design the building so that ensure that the strength of the building is such that it is able to withstand all the expected forces during its lifetime. So structural stability, your National Building Code specifies minimum standards for materials and construction practices to ensure the structural integrity of the building. So you know, as an engineer or as an architect, you might have done design of RCC building for which you have code IS 456 2000, and for design of steel structures you have code IS 800 2007. All these codes are incorporated in this National Building Code. They are part of National Building Code 2006. And then this National Code also contains the topic of fire safety, which is very important. So it includes regulations for fire prevention, detection, and suppression system. For example, building must have fire resistant materials, fire alarms, and sprinkler system to ensure safety. Then another thing which has been provided in the National Building Code 2016 is accessibility. Accessibility means accessibility for the disabled person. So for them, special provisions have to be made in the buildings. You have to provide ramps at certain locations so that they are able to enter and exit the buildings, especially in the rooms, bathrooms. You have to provide special provisions in the bathrooms for the disabled persons. All these things have been included in the National Building Code 2016. So For example, a shopping mall with ramps, wide doorways, and elevators ensures accessibility for users. So all these things have to be provided as far as this National Building Code 2016 is concerned. Accessibility for the disabled persons. Next is in environmental sustainability. So sustainability is an important factor in today's scenario, especially all the architects, they are more concerned with this topic. Of course, it is equally important for all of us. Sustainability, green building constructions, energy efficient buildings, and all these things have been included in the newly National Building Code 2016. So it incorporates friendly practices and materials. For example, a residential complex in Bengaluru uses solar panels for energy and rainwater harvesting system to conserve waters. Then space requirement. So, whenever you have to design or plan a building, so each and every room has a size, minimum size for bedroom, minimum size for living room, for kitchen, for bathrooms, for residential. Similarly, in case of commercial building, minimum size of the staircase, width of the staircase, minimum requirement of bathrooms, passages. All these things have been provided in the National Building Code 2016. So this provides details for adequate room sizes for various functions. For example, in Mumbai, a minimum size of habitable room in a is specified to ensure comfortable living spaces. Then building coverage and floor area ratio. So this thing, all of us know there are two things. With one is plot coverage and other is floor area ratio. So plot coverage is ground floor coverage basically, and floor area ratio. So floor area ratio, it is how many how many times you can have total plinth area as compared to plot area. Means total covered area of all the floors divided by plot area, that will give you floor area ratio. This is also called floor space index many times. So for example, if a plot has FAR 1.5 and size of the plot is, let us suppose, 1000 square feet, then the maximum covered area of the building in this plot will be 1500 square feet, means 1.5 times the size of the plot. And if plot coverage is 60%, it means at ground floor, maximum coverage can be 600 square feet. So whenever you are doing valuation, you have to check as per bylaws what is the maximum permissible ground coverage and maximum covered area as per floor area ratio. So only that portion you can consider for valuation, which is as per permissible bylaws. The excess area has not to be considered in valuation, especially when you are doing valuation for financial institution. Then zoning requirement. So you know all cities are divided into different zones, such as residential zone, commercial zone, industrial zone, and depending upon the zone, means if the property you are doing evaluation falls in a residential zone, it cannot you cannot construct a commercial property there. So whenever you have to do valuation, whenever you have to do valuation, you have to check in which zone this your property falls. If it is a residential, if it is in a residential zone of the city and the property is of commercial type, which is not permissible as per bylaws, you cannot have a commercial property in a residential zone as per bylaws. So you have to check all these things whether it fulfills zoning requirement or not. And then it provides about the aesthetics and design. So maintain architectural harmony and aesthetics, of course, without compromising with the structural stability. You can have aesthetics and architectural designs without compromising with the structural stability of the building. So in heritage zones of Jaipur, buildings must conform to the specific architectural system styles to preserve cultural heritage. Then safety and security. So it provides details about the requirement of security measures and emergency exits. For example, a commercial building in Hyderabad has a CCTV surveillance, security personnel, and clearly marked fire exit for safe. So you know whenever you have to get a plan approved for a commercial, especially for commercial or industrial building, first of all, you have to get an fire safety plan approved from the fire authorities. You have to get fire NOC to prove that the building you are planning conforms to the fire exit and fire regulations. So then compliance and documentation. So before starting the construction of a building, it has to be planned by an approved architect or by an approved engineer. Then this plan has to be get approved from the competent authority. And even during the construction, in many states, and as per bylaws of all the state, it is mandatory to get uh, your plan, your construction approved from the competent authorities at different stages, at plinth level, at superstructure level, and before entering into the building, you have to get your occupation certificate from the competent authority, which is issued after checking all the requirements by the competent authority. So now it has been again a Supreme Court order is there, a recent Supreme Court order, which says that no unauthorized construction is to be allowed or regulated by the authority. So whenever you are doing valuation, you have to be very careful about the unauthorized construction which is beyond the prevalent building bylaws of your state. So practical examples, we will now take some practical examples of all these things. Structural stability scenario. Let us suppose a new apartment building in Mumbai must adhere to the National Building Code guidelines for structural stability, ensuring it withstands earthquakes and other natural calamities. So what the law says that the building should be safe and it should also look safe. It should remain useful for the life period for which it has been constructed. So let us suppose you have constructed a water tank. You fill it with the water after constructing it, but it starts leaking after, let us suppose, 1 year. Though it is safe, it is able to store the water, but it is leaking. It is not serving the purpose for which it has been constructed. So if it is not useful, then your design is not of any use. So it should serve for the life for which it has been designed. So this is what the structural stability says. So next, fire safety. Let us suppose, for example, a shopping mall in Delhi is required to install alarm, sprinklers, and fire resistant materials as per National Building Code regulations for the safety of shoppers and employees. Then sanitation and plumbing. So it sets standards for sanitation and plumbing systems to ensure hygiene and health. For example, residential buildings must have adequate water supply, drainage systems, sewage disposal systems, and nowadays another thing has been added: rainwater harvesting system, which has to be included, especially in the buildings which are of area more than 125 square yards. The provision of rainwater harvesting has to be made in them. Then energy efficiency. It National Building Code 2016, it promotes the use of energy efficient designs and materials to reduce energy consumption. It encourages the use of insulation, energy efficient windows, and renewable energy sources in the building designs. And then accessibility, which we have already discussed, that buildings have to be made accessible to the disabled persons with disabilities. Next in your syllabus is rent control laws. So we have done a number of case studies during our case, especially in income approach method. We have done case studies on buildings which are covered under Rent Control Act and which are not covered under Rent. So now here we will discuss about what is basically Rent Control Act. So it controls or protect tenants from unfair eviction and excessive rent. The main aim of this act is to prevent tenants from unfair eviction and excessive rent. So it ensures that landlords do not enhance the rent arbitrarily. So this is a state subject. This act varies from state to state. Every state it has its own rent control act. So we have to discuss about the things about as far as syllabus is concerned. You must know what are the occupancy rights of the tenants as per this act. First right is right against unfair eviction. So landlord cannot evict tenants without a valid reason. For example, in Delhi, landlord must obtain a court order to evict a tenant. So as an engineer or as an architect, many times you might have act as you might have calculated standard code rent for the code purposes, or you may have acted as expert building expert a builder, building designer in the court of law to help a tenant or to help a landlord. So there are certain certain condition under which the tenants can be evicted. If the tenant has done any material change in the structure of the building, this thing you must know. Tenant cannot make material changes. He may carry out certain repairs, no doubt, but he cannot make material changes. He cannot change the flooring from TC flooring to vitrified tile flooring. He cannot change doors and windows, materials of the doors and windows. He cannot change certain things. So if he does some material change, he may be evicted on this basis. And the second thing, if the landlord is able to prove that building is such that it cannot be repaired, it is beyond repairable, it has to be demolished and reconstructed. If the landlord is able to prove that, or in case an NRI, if he is able to prove that he requires the building for his own use, then the tenant can be evicted. Otherwise, it is very difficult to evict the tenant. So it protects the right of the tenants against unfair eviction. So tenants have the right to occupy the property as long as they comply with the lease terms or rent controlled rent deed or lease deed if they are following the things which are written in the rent deed or lease deed, they cannot be evicted. Then freezing of rent. Standard rent. Standard rent, you all know what is standard rent. What is standard rent? Anybody who can explain what is standard rent?
It is
Fixed by
fixed
court.
by as per the rent control laws, as per that prevailing the rent control laws, depending on the area of the
Depending
rented
upon the
property.
location and amenities, Rent Control Act will decide the rent of the building, I mean house.
So it is the rent which is fixed by the court and is based upon the Rent Control Act of the state. Rent Control Act of the state explains the procedures for calculating the rent, standard rent, how the standard rent is to be calculated. It is based upon the value of the land and value of the building. Certain percentage of the value of the land and on certain percentage on the value of the building. It depends upon the various factors such as locations, amenities provided, and other things. And the next thing is rent hike restrictions. So Rent Control Act, it promulgated that landlords cannot increase the rent beyond the standard rent without the rent controller's approval. So without the approval of the rent controller, landlord cannot have rent more than standard rent if the tenant goes to the court for relief. Then protection against eviction. So landlord can evict the tenants only in specific regions such as non-payment of rent, misuse of property, or the landlord needing the property for personal use. So there, as we have already discussed, that property can be evicted only in certain conditions, certain situations. Otherwise, it is not possible to evict the tenant. And for then, it is not that the landlord will go to the property and throw away the tenants' households. It is not that. He has to approach the court, even if he has certain reason that the tenant can be evicted, but he cannot evict on his own. He has to approach the court, and if the court allow him to evict the tenant, then he will evict the tenant. And if the tenant is not evicting the premises even after getting court order, then the landlord can take the help of police authorities. Even then, he cannot do anything on his own. So this is how the tenant can be evicted. So you know this Rent Control Act, how it affect the value of the property. So you know the rented properties, value of rented properties drastically reduced. Value of the rented property is drastically reduced. You have to do valuation on the basis of income approach method, in which capitalization of the income is done. So rent control can limit the rental income you know, there is freezing of the rent. You cannot get rent beyond the standard rent. So thereby reducing the property's market value. So attractiveness to tenants. So these laws can make properties more attractive to the tenants, potentially increasing demand and stabilizing property values. So as you know, each state has its own rent control act. For example, Delhi Control Act 1958. This act regulates the rental markets in Delhi, fixing standard rents and providing eviction protections. And similarly, Maharashtra Rent Control Act 1999. It is similar to Delhi Rent Control Act. It governs the rent control in the Maharashtra state, ensuring fair treatment for both landlords and the tenants. Then the sections pertaining to occupancy rights of the tenant. As you know, each state has its own rent control act. We will be taking the examples of certain states. For example, in Delhi Rent Control Act, Section 14, it deals with the protection against eviction. So a tenant cannot be evicted without valid reasons such as non-payment of rent, misuse of property, or the landlord needing the premises for personal use. So Delhi.
See, these acts are very, very important as a valuer's perspective. If you are valuing a property which is on rent and you are valuing that property in favor of the owner of the property, then you can be in trouble and you have to listen to loud music after a few months or years if the bank is not able to get the clear possession of this property at the time of NPA. Yes, sir. Please continue, sir.
So as Sandeep ji have very well explained to you, that let us suppose the person has taken a loan for mortgaging his property which he has given on rent. And as a valuer, it was your duty to do the valuation on rent control property as income. You have to use a net income and then capitalize this income to get the value of the property, and also inform the banks that this property is under tenancy. Let us suppose after a period of 1 year, the case becomes NPA and you have done the valuation on the basis of land and building, on the basis of cost approach. Then what will be the scenario? As per Supreme Court orders, tenants, even then, bank cannot evict the tenants. Bank can only have rent from the tenants. They cannot force the tenants to evict the building. And the bank cannot sell that property forcefully. So you will be in trouble at that time. So please make sure that if the property is under tenancy, you do the valuation as per income approach and inform the bank authorities appropriately. And in Maharashtra Rent Control Act 1999, Section 15 of the This act gives right to the tenants. Then similarly in Tamil Nadu, Buildings Lease Control Act 1960, the section 10 gives the conditions for eviction of tenants. So, for example, protection from arbitrary eviction. A tenant in Mumbai who pays rent regularly cannot be evicted without a valid reason. If the landlord attempts to evict the tenant without cause, tenant can seek protection from the under Maharashtra Rent Control Act. Similarly, right to peaceful occupation. So tenant has the right to peaceful occupation of the premises which he have taken under rent. For example, a tenant in Chennai has a lease agreement and is complying with its terms. The landlord cannot disturb the tenant's peaceful occupation unless there is a legitimate breach of the lease, such as non-payment of rent. These sections ensure that tenants have secure occupancy and cannot be unfairly evicted, providing stability and security to the rental arrangements. That is tenants' protection in action. Then freezing of rent. Rent
Excuse me,
freezing
sir.
is a regulatory mechanism that ensures that limits the amount landlords can increase rent on residential properties over a period of time. So first thing you must understand what is freezing of rent. The freezing of rent is a regulatory mechanism that limits the amount landlords can increase rent on residential properties over a period of time. It is designed to protect tenants from excessive rent hikes, especially in high demanded areas where rental prices can skyrocket. Its purpose is to keep housing affordable and prevent sudden unaffordable rent increase. It is typically enforced by local government for housing or the housing authority. So its duration can be temporary during economic crisis or permanent, for example, rent controlled cities. For example, in COVID-19 pandemic, many countries implemented rent freezes to help tenants facing financial hardship during pandemic. Then there are, in case of long-term leases, some furnished apartments provide offer rent-free option for long-term leases. For example, some clubs allow tenants to pause their lease for extended vacation or family visits. Then what are the legal implications of rent freezing? During rent freezes, landlord may still increase the rent with special permissions. For example, property improvement or mutual agreement with the tenant. Then protection against eviction of tenant. This ensures that tenants cannot be forcefully removed from their rented property without a valid reason, and a due legal process has to be carried out for evicting them. So this protection is crucial for maintaining housing stability and preventing homelessness. So what is the effect on the property value of these two terms. First, it may be positive impact or it may be negative impact. So first we will consider its positive impact. It can lead to a stable tenant base, reducing turnover and vacancy rates, which can be beneficial for landlords in the long run. And for its negative rent impact, it may deter investment in rental property due to perceived restriction on landlords' rights, potentially leading to decrease in the supply of rental house. Next is right of way under Indian Easement Act 1882. So basically, what is easement? So you have a right, certain right over the property of which you are not the owner. You have a right on another property or other property of which you are not an owner, basically, in layman's term. Easement is you have a right on someone else's property of which you are not an owner. You have certain right. So first is right of way. The right of way is a type of easement that allows the owner or occupier of one piece of the land, the dominant tenement, to pass over another land, the servient tenement, for access. For example, this is dominant terminant. This person do not have direct access on the road. For going to the road, he has to pass to this property. So here has been a passage have been provided. This is easement. This is called easement. So this is dominant tenement and this is servient tenement. So the person on whose property this right is provided, he is called servant. And the person who gets this right is called dominant tenement. Dominant owner or dominant tenement and servant owner or servant tenement. So this is basically right of. If a person A owns a piece of land that is only accessible by crossing other person's property, person A can have a right of way over person B to get access to his own property. Section 52 of licenses. This is licenses under Indian Easement Act 1882. So you must understand what is license. A license is a personal privilege granted by one person who is called a licensor to another person who is called a licensee to do something on licensor's property which would otherwise be unlawful.
And there are three terms: lease, rent, and license. All the three terms are different and with different meaning and different rights on the property. As a valuer, you must know what is the basic difference between the three terms and how to value the property with a particular occupancy rights of the tenant and owners. Yes, sir. Please continue, sir.
So first thing you must understand what is license. So license, it is a personal privilege granted by one person who is called a licensor to another person who is called a licensee to do something on licensor's property which would otherwise be unlawful. For example, a shop owner allows a street vendor to set up a stall on their property for a day. This is a license. The vendor has permission to use the property, but this does not give them any interest in the property itself. Remember, in case of lease, the lessee has some interest in the property, but in case of license, the licensee do not have any interest in the property. He can use it for a certain purpose for which he has been given license by the license. There are certain practical example. One is right of way. As we have already discussed that a person A's property is this is a landlocked. This is a landlocked land and he has to pass through person B's property, let us suppose servant owners. So this is right of ways under Indian Easement Act. And license, we have already discussed about a mall owner allows a food truck to park in the mall parking lot for a weekend food festival. The food truck has the permission to use the space, but thus this does not give them any ownership rights over the parking lot. Next is salient features of Real Estate Regulation and Development Act 2016, which is also called RERA. First thing is establishment of Real Estate Regulatory Authority or RERA authority. So each state and union territory has its own Real Estate Regulation and Development Authority, RERA authority. Its purpose is to regulate the real estate sector and ensures transparency. For example, Maharashtra RERA ensures that all real estate projects within the state are registered and comply with the regulation. So all real estate developers have to get themselves registered with the RERA of that particular state before starting any project. And it has to be constructed, accomplished as per the RERA Act of the state. So it is mandatory registration of real estate project. So all commercial and residential estate projects exceeding 500 square meters or 8 apartments must be registered with RERA before advertising and selling. For example, a developer in Delhi must register new residential project within Delhi RERA before launching it. What this act actually says? The most important thing is public disclosure of project details. So developers must disclose the project details such as layout plans, status of approvals, and details of real estate agents, contractors, and architects on the RERA website. For example, a project in Karnataka must provide all relevant information on the Karnataka RERA website for public access. Then rights and duties of allottees. What are the rights and duties of the buyers? Buyers must receive the accurate information about the project. including the status of approvals, land title, and layout plans. For example, a buyer in Uttar Pradesh can request and receive detailed project information from the Uttar Pradesh RERA. Then timely completion and penal provisions. So developer must complete projects within the agreed timeline, and delays can result in penalties, including compensation to the buyers. For example, a developer in Gujarat who delays a project completion may be required to pay compensation to the buyers as per Gujarat RERA regulation. Next is regulating authorities established under the Act. First authority is Real Estate Regulatory Authority. Each state establishes its own real estate regulatory authority. For example, Tamil Nadu RERA oversees real estate projects in the Tamil Nadu, ensuring compliance with the Act. Then the Real Estate Appellate Tribunal. It is established to hear appeals against decisions made by RERA and adjudicate disputes related to real estate projects. Then Central Advisory Council. It is formed to advise the central government on matters related to real estate sector and suggest measures for its growth and promotion. For example, Central Advisory Council in India provides recommendations to the central government on real estate regulation and regulation process. ठीक है संदीप जी, you can have a tea break. After that, we will start with the Transfer and Property Act 1882.
Yes, sir. So friends, let's have a tea break of, let it be, sir, can we take a tea break of 25 to 30 minutes?
ठीक है सर.
So it is 11:20 now. We will join sharp at 11:50. Till then, you can switch off your screens.
Thanks, sir.
Before starting our next topic, I would like to introduce our youngest director of any RVO, Engineer Vaibhav Bansal ji. He is a qualified independent director, and he has also is a certified faculty for intellectual property rights, NIPAM, Ministry of Commerce and Industries. He is registered with the Independent Directors Data Bank, IDDBF of Indian Institute of Corporate Affairs. He is BTech in Civil Engineering with this distinction from David Jalandhar. He has done, before that, he has done Diploma in Civil Engineering with State Board Merit Position and awarded appreciation from his Polytechnic, M. Meherchand Polytechnic College, Jalandhar. He has also done 6 months course in Real Estate Valuation from Technological Development Center, PPDC, Ministry of MSME. He is certified gold appraiser from Technology Development Center, PPDC, Ministry of MSME. He is affiliate member of American Society of Civil Engineers. He is associated member of Institution of Engineers. He is also a chartered engineer. He has authored more than 6 books with ISBN registration, Department of Higher Education, Ministry of Education. And he is also a member of Punjab Press Club and sub-editor in CEV Techno News. At present, he is doing LLB and is a second-year student of law. We will take his services for having certain knowledge about the Indian Succession Act which you know is very important for a valuer to know about the basic details, which as an engineer or an architect, we cannot understand many things about this act. So especially for the Hindu Succession Act. So he will guide us certain basic things about this act. So after that, we will continue with our topic. So I request Engineer Weber Bansal to give some details about this subject.
Thank you very much, sir. Thank you for my introduction. So friends, today we will discuss a very important terms of Hindu Succession Act 1956. So let me share my screen. Is my screen visible to all?
Yes, sir.
Yes, sir.
Yes, please.
Is my screen visible to all? All of you?
Yes, sir.
Yes, sir.
Okay. So today we will discuss some salient features of Hindu Succession Act 1956. So first of all, we will discuss the applicability of this act. So the Hindu Succession Act 1956 came into force on June 17th, 1956. It was enacted by Parliament of India as Act 30 of 1956. The applicability, as per Section 2(1) of this act applies to any person who is a Hindu by religion. Next, to any person who is a Buddhist, Jain, or Sikh by religion. And the last, to any other person who is not a Muslim, Christian, Parsi, or Jews by religion. So this was the applicability, and now we will discuss the very important terms related to this section, which are generally asked in examination and also important for professional life as valuable. So first of all, we will understand the terms agnates, cognates, and collaterals. Under Hindu Succession Act 1956, the term agnate, cognate, and collaterals refer to different categories of relatives that are used to determine the order of inheritance. So agnates, these are the relatives connected solely through male lineage. Agnates have the highest priority of inheritance under the Hindu law. Example include a father, a grandfather, a grandson, and their descendants. As per Section 18 in general terms, you can see that agnates are preferred over cognates and cognates are preferred over collaterals. Now cognates. Whenever in the relationship of a person with another, a female intervenes anywhere in the line, one is cognate to another. In agnates, there were wholly through males, but in cognates, anywhere in line, one cognate, one female intervenes there. So whenever a female intervenes anywhere in the line of succession, they are said to be cognate. They come after agnates in the order of succession. Examples include maternal relatives and siblings. The next term is collaterals. Relatives connected through common ancestor or ancestors, but not directly in the line of descent. That is, they are in parallel line. They have the lowest priority. Examples include siblings of the deceased and their descendants, means siblings of the deceased. Now, as per Section 3A agnates, this section is in Hindu Succession Act 1956. In Hindu Succession Act 1956, Section 3A agnate. One person is said to be an agnate of another if the two are related by blood or adoption wholly through males. By blood or by adoption wholly through males. As per Section 3C cognate, one person is said to be a cognate of another if the two are related by blood or adoption, but not wholly through males.
Friend, this is very important concept agnate and cognate. Many times a question is being asked on this topic. What is mean by agnate? What is mean by cognate? You must know what is mean by agnate and cognate. We will learn these things as mentioned in this table. It will be more clear if you read this table along with. Yes, Mr.
So here's a detailed comparison in tabular form. Agnates. Now the meaning of agnates. Agnates are relatives related through male lineage. In agnatic relations, the connection is through the male line only, In cognates, whenever in the relationship of a person with another, a female intervenes anywhere in the line, one is cognate to another. They include relatives on both father's and mother's side. In agnates, we are not concerned with mother's side relatives.
Can you please zoom in, please? Can you please zoom in a bit more?
Okay. Okay, sir. Now it is clear?
Yes, sir.
Yes.
Thank you.
Yes, sir. Thank you.
Now in cognates, whenever in the relationship of a person with another, a female intervenes anywhere in the line, one is cognate to another. They include relatives on both father's and mother's sides. Now in collaterals, what is the meaning of collaterals? Collaterals are relatives related through a common ancestor, but not directly in the line of descent. That are siblings of the deceased. Means brother, sister, etc. are the siblings of the deceased. They are called collaterals. They are in parallel lines. Now, preference in succession. This is very important.
Disease means about whose property we are discussing or whose property is to be distributed among the successors.
Yes, the deceased is also called propositus. We will discuss that term also in detail. Now, preference in succession. Agnates have precedence over cognates in order of succession, order of inheritance. Cognates are considered after agnates, but before collaterals. And collaterals are considered last in the order of succession. So collaterals are considered last in the succession, and agnates are considered have the precedence over cognates in order of inheritance. Now examples. Examples of agnates are full brothers and their descendants, like great-grandfather, paternal uncles, male descendants of these relatives. Cognates. The examples of cognates are maternal uncles and aunts. Any other relative of the deceased, including maternal relatives. Now collaterals. Examples of collaterals are siblings of the deceased, their descendants like nephews and nieces, cousins who are not direct descendants of the deceased parents. Now legal status. Agnates have the highest priority in succession. Cognates have a secondary priority considered only after agnates. Collaterals have the lowest priority among these categories. Now we will discuss half-blood, full-blood, and uterine blood relation as per Hindu Succession Act 1956. As per Section 3E.
Friends, these relations are very important to be understood by every valuer. Anytime when you encountered a will during your visit and you have to value that property, and the person said that I have acquired this property as per will of my father, uncle, or any other relative, then you must know how to value this property and who is having the more right of ownership on that particular document. Yes.
Yes. So now we will understand various blood relations as per Hindu Succession Act 1956. As per Section 3E, full blood, half blood, and uterine blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife. And by half blood when they are descended from a common ancestor but by different wives. Two persons are said to be related to each other by uterine blood when they are descended from a common ancestress but by different husbands. So here fathers are different. Here in half blood, mothers are different. And in full blood, both are same. Mother and father, both are same. So explanation, in this clause, ancestor includes father and ancestress include mother. Now, as per section 18, full blood prefer to half blood. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood if the nature of the relationship is the same in every other respect. So now let us discuss in detail in tabular form. Now, meaning of full blood. When the father and mother of two persons are the same, they are related to each other by full blood. In half blood, when two persons have the same father but different mothers, they are related to each other by half blood. And in uterine blood, when two persons have the same mother but different fathers, they are said to be related to each other by uterine blood.
So friends, is the three terms are clear in your mind? कोई doubt है तो पूछिए.
So if you have any doubt, you can ask between the lecture. Now, preference in succession. Full blood relatives have a higher priority in succession compared to half blood and uterine blood. In half blood relatives are considered after full blood relatives, but before uterine blood relatives. And uterine blood relatives are considered last in the line of succession among these categories. So now examples, full blood brothers and sisters, same mother and father, half brothers and half sisters, sharing the same father but different mothers, uterine brother and sisters, sharing the same mother but different fathers. Now, legal status, as per section 18, as we have already discussed, full blood preferred to half blood. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood if the nature of the relationship is the same in every other respect. Now, half blood relatives are recognized but are not given precedence over full blood relatives. As per the schedule of Hindu Succession Act 1956 explanation, this explanation is given in the schedule of the Hindu Succession Act 1956. In this schedule, references to a brother or sister do not include references to a brother or sister by uterine blood. So the references given in schedule of the Hindu Succession Act does not include uterine blood relation. Now, rights of child in womb. The child is in womb, not yet born. As per section 20, right of child in womb. A child who was in the womb at the time of the death of an intestate and who is subsequently born alive shall have the same right to...
Intestate means जिसने अपनी will नहीं की है. यहाँ पर एक इंटरस्टेट एक वर्ड इस्तेमाल हुआ है. अगर कोई आदमी अपनी बिना विल किए उसकी डेथ हो जाती है तो उस केस में क्या क्या राइट्स होंगे आगे सक्सेशन के लिए? यस प्लीज.
A child who was in the womb at the time of the death of an intestate and who is subsequently born alive shall have the same right to inherit to the intestate as if he or she had been born before the death of the intestate, and the inheritance shall be deemed to vest in such as a case with effect from the date of the death of the intestate. So next, intestate succession. A person who dies without making a will is known as intestate. As per section 3, clause G, a person is deemed to die intestate in respect of property of which he or she has not made a testamentary disposition capable of taking effect. So where a person, जब कोई person ने will नहीं बनाई, अपनी वसीयत नहीं बनाई और उससे पहले उसकी डेथ हो जाती है, तो फिर जो प्रॉपर्टी होगी वो deemed to die intestate उसको माना जाएगा और वो प्रॉपर्टी डिवॉल्व होगी अकॉर्डिंग टू दिस एक्ट, और इसके सेक्शन 8 उस पर अप्लाई हो जाएगा, सेक्शन 8 ऑफ हिंदू सक्सेशन एक्ट 1956. नाउ टेस्टिमेंटरी सक्सेशन. As per section 30, testamentary succession. Any Hindu may dispose of by will or other testamentary disposition any property which is capable of being so disposed of by him or by her. The words disposed by him or by her was added by Hindu Succession Amendment Act 2005. In accordance with the provisions of the Indian Succession Act 1925 or any other law for the time being in force and applicable to Hindus. So testamentary succession होती है जब उसने will बनाई है. When there is a will. Now here's a person who is entitled to inherit property after the death of the intestate is known as heir. As per section 3, clause F, heir means any person, male or female, who is entitled to succeed to the property of intestate under the act. Now, descendants and ascendants. Sometimes this term might confuse you. Who are descendants and who are ascendants? Now, descendants. Descendants means the offspring of a person. Immediate descendants of a person are his sons and daughters. A person may have descendants through his sons or daughters up to any degree of descent. For example, son, grandson, daughter, granddaughter, etc. Now, ascendants. Ancestors of a person are known as ascendants. Immediate ascendants of a person are his father and mother. For example, father, grandfather, great-grandfather, mother, grandmother, etc. Now the term proposita. The term proposita refers to the person whose property is being dealt with in a succession matter.
Sometimes when you read a will or a document, testamentary document, you may encounter this word proposita. What is meant by proposita? You must know.
It is essentially the individual who has passed away and whose estate is being inherited or disposed of under the laws of succession. Proposita refers to the deceased person who is the subject of the succession, and the law determines how their property will be distributed among the heirs. In simple terms, proposita means the deceased individual whose succession is being discussed or decided. Now, general rules of succession in the case of wills. As per section 8, general rules of succession in the case of males, the property of a male Hindu dying intestate shall devolve according to the provisions of this chapter. Firstly, upon the heirs being the relatives specified in class 1 of the schedule. Secondly, if there is no heir of class 1, then upon the heirs being the relatives specified in the class 2 of the schedule. Thirdly, if there is no heir of any of the two classes, then upon the agnates of the deceased. And lastly, if there is no agnate, then upon the cognates of the deceased. So, as per the provisions of this act, if a Hindu male dies intestate, then the following persons can make a claim. First claim, first class 1 legal heirs. They have equal rights to the assets. They are mother, spouse, children, etc. If any child has died, then their children and spouse have an equal share. Second claim, in the absence of class 1 heirs, the class 2 heirs can make a claim. They are father, sibling, living children, grandchildren, siblings, children, etc.
Here you must concentrate on the second claim. Father comes in second claim, not in first claim. Father is a second class higher, not a first class higher. You must know this.
So now third claim, in the absence of class 1 and class 2 heirs, the agnates can make a claim. Agnates can be defined as distant blood relatives of male lineage, father's side. And the fourth claim, in the absence of class 1, class 2 heirs, and agnates, the cognates can make a claim. Cognates can be defined as distant blood relatives of a female line. So firstly जो है वो class 1 heirs को ही जो है property उन्हीं को शेयर मिलेंगे। सेकंड क्लेम किनका होगा? इन द एब्सेंस ऑफ क्लास वन, मतलब क्लास वन में जो 16 रिलेशंस मेंशन्ड हैं शेड्यूल में, अगर उनमें से कोई भी रिलेटिव जो है उसका अवेलेबल नहीं है, तो सेकंड क्लेम क्लास टू हेयर्स को मिलेगा, जो कि उसमें एंट्री वाइज उसमें 9 एंट्रीज हैं शेड्यूल 2 में, तो उन 9 एंट्रीज में वो मेंशन्ड है। जो फर्स्ट एंट्री होगी वो सेकंड एंट्री और लास्ट एंट्रीज को एक्सक्लूड कर देगी, और जो सेकंड एंट्री होगी वो उसके नीचे वालों को एक्सक्लूड कर देगी। तो हायर द एंट्री द लोअर विल बी एक्सक्लूडेड। सो सेकंड क्लेम क्लास टू हेयर्स को मिलेगा। और थर्ड क्लेम जो है, अगर क्लास वन और क्लास टू दोनों हायर्स नहीं है तो एग्नेट्स को मिलेगा। एग्नेट्स अभी हम डिस्कस कर चुके हैं कौन होता है। और फोर्थ और लास्ट क्लेम किनको मिल सकता है? कॉग्नेट्स। तो कॉग्नेट्स लास्टली प्रेफर करे जाएंगे। और अगर कॉग्नेट्स भी नहीं होते, एग्नेट्स भी नहीं होते, क्लास वन क्लास टू कोई हायर नहीं होता किसी का, तो फिर एस्टीट होती है। एस्टीट क्या होती है वो हम आगे डिस्कस करेंगे। नाउ these are the class 1 heirs. These are 16 relations mentioned in schedule of the Hindu Succession Act 1956. You can see here some important, very important relations are mentioned here, like son, daughter, widow, mother, son of predeceased. Predeceased का मतलब है जो सक्सेशन ओपन होने से पहले ही उसकी डेथ हो चुकी थी, मतलब प्रोपोसिटस से पहले उसकी डेथ हो चुकी थी। He died before the propositus. Now second आता है daughter of predeceased son, son of a predeceased daughter, daughter of predeceased daughter, widow of predeceased son, son of a predeceased son of a predeceased son, daughter of predeceased son of a predeceased son, widow of a predeceased son of a predeceased son. Now these within the bracket are added after the amendment of 2005. ये जो सारे रिलेशन आप ब्रैकेट में देख रहे हो जिनके आगे 1 लिखा है, ये सारे जो ऐड किए गए थे वो 2005 की अमेंडमेंट में किए गए थे। तो कि यहाँ पर कुछ ऐसे कोग्नेटिक रिलेशंस थे जो नहीं थे क्लास 1 हायर्स में, ये क्लास 2 में थे ऑलरेडी, लेकिन इनको अमेंडमेंट के बाद क्लास 1 में ऐड कर दिया गया ताकि इनके साथ भी इक्वल जस्टिस हो सके। नाउ क्लास 2 हेयर्स। क्लास 2 हेयर्स में ये जो 1 2 3 रोमन न्यूमेरिकल्स में लिखा है, ये सब एंट्रीज है। जो भी फर्स्ट एंट्री में होगा वो बाकी सबको एक्सक्लूड कर देगा। जैसे फादर, सो फादर फर्स्ट एंट्री में है, तो ये लास्ट के सारे जो है इनको कुछ भी नहीं मिलेगा अगर फादर इस वक्त जो है वो मतलब जिंदा है, मतलब वो अभी लिविंग पर्सन है, तो फिर इनको कुछ भी नहीं मिलेगा। अगर फादर नहीं है तो ये सेकंड एंट्री में सन्स डॉटर सन, सन्स डॉटर्स डॉटर, ब्रदर सिस्टर, इनको फिर शेयर मिलेगा और बाकी सबको नहीं मिलेगा। ऐसे ये एंट्रीज 1 2 3 4 से लेके 9 तक है। और इसमें लास्ट रिलेशन है मदर्स ब्रदर एंड मदर्स सिस्टर, मतलब मामा और मासी, ये लास्ट में। नाउ की टेक अवेज फ्रॉम क्लास 2 heirs. Father is the only nearest heir who has not found a place in class 1 heirs. As per the Mitakshara notion of propinquity.
Friends, it is very important concept. It is very important concept to be understood by everyone. Father is the only nearest heir who has not found a place in class 1 heir. Very important. हालांकि हम जब भी बोलते हैं लेट इट बी, किसी का नाम बोलते हैं उसके साथ सन ऑफ उसके फादर का नाम जरूर लगाते हैं, लेकिन लीगली father is the only nearest heir who is not found a place in class 1 heir. It is very important concept to be learned by every valuer. कभी कभी अभी एक कोर्ट का केस हुआ है, उसमें ये हेल्ड किया गया है कि ऐसा, ये अगर आप इग्नोर करते हैं, मैं ज्यादा डिस्कस नहीं करूंगा, अगर आप इग्नोर करते हैं तो यू कैन बी इन ट्रबल while valuing a property. Yes, please continue.
Yes sir, thank you. So as per Mitakshara notion of propinquity, अब ये मिताक्षरा क्या है? There are two schools in Hindu law, two major schools. One is Mitakshara and other is दयाभाग। मिताक्षरा जो है वो नॉर्थ इंडिया और सारे इंडिया में एप्लीकेबल होता है, लेकिन दयाभाग सिर्फ और सिर्फ जो है वो बंगाल साइड में ही एप्लीकेबल होता है और ईस्टर्न स्टेट्स में एप्लीकेबल होता है। सो मिताक्षरा को ही इसमें कंसिडर किया गया है। और एज पर मिताक्षरा नोशन ऑफ प्रोपिंक्विटी, अब प्रोपिंक्विटी का मतलब होता है नियरनेस ऑफ रिलेशन, दैट अंडर द मिताक्षरा लॉ मदर वॉज कंसिडर्ड टू हैव ग्रेटर प्रोपिंक्विटी देन फादर। सो मदर को जो है वो ज्यादा नियर माना जाता है फादर के। और इवन इन द केस ऑफ लिजिटिमेट एंड इलिजिटिमेट सन, जो मदर है उसका राइट जो होता है प्रॉपर्टी पे होता है, और जो इलिजिटिमेट सन होता है उसका प्यूनेटिव फादर की प्रॉपर्टी पे राइट नहीं होता, लेकिन अपनी मदर की प्रॉपर्टी पे राइट होता है। सो इसीलिए मदर को ग्रेटर प्रोपिक्विटी कहा जाता है. Now, father is the sole heir in category 1, and in the absence of class 1 heirs, he takes the entire property. So, अगर class 1 में कोई भी नहीं है, तो father अगर उस वक्त living person है, तो father को entire property मिल जाएगी और बाकी सबको वो exclude कर दे, पर class 1 के ना होने पे. Now, brothers and sister of equal rank inherit equally. When there is brother or sister by full blood, brother or sister of half blood is excluded. So full blood जो है वो half blood को exclude करते हैं, जैसा हमने पहले पढ़ा. The brother and sister by uterine blood are excluded. Brother और sister of uterine blood जो है वो कभी भी पिक्चर में नहीं आते जब तक कि half blood और full blood है, और अगर half blood और full blood नहीं है तो वो आ सकते हैं. लेकिन शेड्यूल में जो लास्ट में जो एक्सप्लेनेशन है उसमें ये लिखा हुआ है the brother and sister by uterine blood are excluded. Now, all heirs in class 2 inherit per capita. Per capita means per head. Now, this is very important term is cheat. As per section 29, failure of heirs. If an intestate has left no heir qualified to succeed to his or her property in accordance with the provisions of this act, such property shall devolve on the government. So, अगर क्लास 1, क्लास 2, एग्नेट, कॉग्नेट कोई भी रिलेटिव नहीं है तो वो प्रॉपर्टी जो है वो गवर्नमेंट को चली जाएगी. इसी को चीट कहते हैं. एंड द गवर्नमेंट शैल टेक द प्रॉपर्टी सब्जेक्ट टू ऑल द ऑब्लिगेशंस एंड लायबिलिटीज टू विच एन हायर वुड हैव बीन ए सब्जेक्ट. Now we will discuss a very important topic, disqualification of an heir under the Hindu Succession Act. Who can be disqualified from succession? As per section 25, murderer disqualified. A person who commits murder or abets the commission of murder shall be disqualified from inheriting the property of a person murdered or any other property in furtherance of the succession to which he or she committed or abetted the commission of the murder. So अगर कोई
yes please continue.
अगर कोई मर्डर करता है या उसकी कमीशन में असिस्ट करता है यानी अबेट करता है तो फिर उसको डिस्क्वालीफाई कर सकते हैं. फॉर एग्जांपल, अगर कोई सन इन अपनी प्रॉपर्टी लेने के लिए फादर का मर्डर कर देता है तो ऐसे में उसको वो प्रॉपर्टी नहीं मिलेगी क्योंकि उसने सक्सेशन के लिए फादर का मर्डर कर दिया. तो कि वो सक्सेशन वो प्रॉपर्टी लेना चाहता था तो उसने उसी इंटेंशन से उसका जो वो था मतलब एनिमस था वो यही था कि वो प्रॉपर्टी ले सक्सेशन करे, तो ऐसे में उसको प्रॉपर्टी नहीं मिलेगी. नाउ एज पर सेक्शन 26, कन्वर्ट्स डिसेंडेंट्स डिस्क्वालिफाइड where before or after the commencement of this act a Hindu has ceased or ceases to be a Hindu by conversion to another religion, children born to him or her after the conversion and their descendants shall be disqualified from inheriting the property of any of their Hindu relatives unless such children or descendants are Hindus at the time when the succession opens. अब यहाँ पर एक चीज इंपॉर्टेंट है कि यहाँ पर जो कन्वर्ट हुआ वो डिस्क्वालीफाई नहीं हुआ क्योंकि कास्ट रिमूवल एक्ट 1850 के अकॉर्डिंगली क्या है कि जो व्यक्ति कन्वर्ट होता है वो प्रॉपर्टी में अपना हक ले सकता, उसकी सक्सेशन नहीं हटाई जा सकती. लेकिन जो उसके चाइल्ड बॉर्न हुए वो उसी रिलीजन के होंगे जिसमें वो कन्वर्ट हुआ, तो वो चाइल्ड जो है वो एक्सक्लूड कर दिए जाएंगे, उनको कुछ नहीं मिलेगा. यहाँ क्लियरली लिखा है कन्वर्ट्स डिसेंडेंट्स डिस्क्वालीफाइड, नॉट कन्वर्ट डिस्क्वालीफाइड. सो कन्वर्ट के जो डिसेंडेंट्स होंगे, जो उसके चिल्ड्रन होंगे, हमने भी डिसेंडेंट्स भी पढ़ा है कि जो उसके चिल्ड्रन होते हैं, तो वो सारे के सारे जो है वो डिस्क्वालीफाइड हो जाएंगे क्योंकि वो कन्वर्ट के चिल्ड्रन है और उनका रिलीजन वही है, वो पहले कभी भी हिंदू नहीं थे, इसीलिए वो डिस्क्वालीफाई हो गए. नाउ एज पर सेक्शन 27, सक्सेशन व्हेन heirs disqualified. If any person is disqualified from inheriting any property under this act, it shall devolve if as such person had died before the intestate. So यहाँ बेसिकली ये माना जाएगा कि वो पर्सन एग्जिस्ट ही नहीं करता, जो डिस्क्वालीफाई हो गया है वो ये माना जाएगा कि वो एग्जिस्ट ही नहीं करता, तो वो come into picture आएगा ही. Now the last, as per section 28, disease, defect, etc., not to disqualify. No person shall be disqualified from succeeding to any property on the ground of any disease, defect, or deformity, or save as provided in this act on any other ground whatsoever. So disease, defect, deformity जो है अब डिस्क्वालीफाई उसके बेस पे कोई नहीं होगा. हिंदू सक्सेशन है 1956 आने के बाद डिजीज और डिफेक्ट को अब डिस्क्वालीफाई नहीं माना जाता. So thank you very much for listening me. If you have any doubt, you can ask.
So friends, if you are having any doubt related to this topic, you may unmute yourself and ask the question, or you may raise your hand.
बांसुल जी.
Yes sir, yes sir.
बांसुल जी.
Yes sir.
बहुत बहुत मुबारक. Nice representation by Vaibhav.
Thank you, sir.
Okay. We met on January 20 when you are doing degree at second year, if you remember.
Yes sir, yes sir. I think it was gold valuation
Yes,
course.
gold appraisal course.
No, when we have delivered COP.
Okay.
Yes, sir. In COP also.
2020 before COVID.
Yes, 29th of
होटल
September.
था कौन सा? हाँ, JK
29th of September.
Very nice, very nice.
Thank you, sir.
Thank you, Mr. Vaibhav Bansal ji.
Thank you, sir.
And I have a small doubt.
Yes, sir.
As we are taking course under the Companies Act, can we, after obtaining the being certified by as a valuer, can we go for the valuation of a family?
Sir, I am unable to hear you. There is a noise in background.
Sorry, sir. After the session, okay, I'll try to chat it.
Yes sir. Yes.
Okay, thank
Sir, I have a question.
Yes, sir.
See, if a person is convicted, as you said, if a person in a succession is making a murder, he is
Yes,
not
sir.
eligible for the rights of a property. In the same way, if a person is murdered in some other activity, let's say he did some murder activity outside, so do he has a right for the property?
Sir, if he has murdered the propositus, then only he is disqualified. If he is a murderer in any अगर उसने किसी और का मर्डर कर दिया तो वो कम इनटू पिक्चर नहीं आएगा. ओनली जब उसने प्रोपोसिटस का मर्डर किया तभी, फॉर सक्सेशन पर्पस ओनली. हियर फैक्टम एंड एनिमस इज दैट कि उसने अपने प्रोपोसिटस का मर्डर किया है, जिसके उसने सिर्फ और सिर्फ सक्सेशन के लिए मर्डर किया.
Clear. मेरा final doubt है, there are two siblings. One is sister, one is brother.
Yes,
so there is interstate condition. The brother has been converted into Christian religion. Okay.
Yes, sir.
So now the property has to be distributed. So
Yes,
how these two will be liable for the property, or only the sister can take the property?
Sir, both will take property equally, half. As मैंने पहले भी यहाँ पर डिस्कस किया था, convert descendants are disqualified, not the convert disqualified. If he is predeceased, then he will take nothing. But if he is living person, he will take his share.
Okay, thanks.
Means sir, वो person eligible होगा succession लेने के लिए, लेकिन उसके जो आगे successors आएंगे वो नहीं होंगे, क्योंकि वो पहले हिंदू था, हिंदू के बाद कन्वर्ट होके क्रिश्चियन या व्हाटएवर इट इज किसी भी रिलीजन में चले गया, तो उसमें वो तो खुद पहले हिंदू रहा है, लेकिन उसके जो आगे सक्सेसर्स होंगे वो हिंदू नहीं कहलाएंगे. तो इसलिए हिंदू सक्सेशन एक्ट में उनको सक्सेशन नहीं मिलेगा, लेकिन अगर वो कन्वर्ट हुआ है इमीडिएट कन्वर्ट वाले को उसको मिलेगा, उसके ब्रदर को मिलेगा, ब्रदर के बच्चों को नहीं मिलेगा.
सर, इसके ऊपर एक लेजिस्लेशन है, कास्ट डिसेबिलिटी रिमूवल एक्ट 1850, वो उस पे एप्लीकेबल हो जाता है, तो हम उसको एक्सक्लूड नहीं कर सकते क्योंकि उसका राइट है अपने फादर और मदर की प्रॉपर्टी पे. लेकिन उसके जो चिल्ड्रन हैं, जो उसके डिसेंडेंट्स हैं, उनको हम कंप्लीटली एक्सक्लूड कर सकते हैं अगर वो उसकी डेथ हो चुकी है तभी, अदरवाइज नहीं.
Sir, in class 1, the predeceased wife was included, no, sir?
1 minute.
Yeah.
In class 1, what?
One. In class 1, there was a point where the widow of the predeceased is included.
The widow of
class
the
1 here.
predeceased.
Class 1 here.
Yes, widow is included. In class 1,
But you
widow
said,
is included.
okay.
And
But
widow
in the
will take
last
equal
point,
share. And widow will take equal share as mother and son.
but in that last slide, the predeceased son is not included, no?
Where?
Last slide, sir. Last
Disqualification.
slide. Yeah. Disqualification. Yeah.
Where it is mentioned?
Sir, third point, section 27. If the person,
If any person is disqualified from inheriting any property under this act, it shall devolve as if such person had died before the intestate. Here it means कि वो पर्सन डिस्क्वालीफाई हो जो पर्सन जो मर्डरर है या कन्वर्ट के डिसेंडेंट्स हैं उनकी प्रॉपर्टी जो है वो जो है ऐसे मानी जाएगी जैसे वो एग्जिस्ट ही नहीं करते. इसमें कहीं विडो का कॉन्सेप्ट नहीं है.
So friends, this is all for this session. If you are having any question, you may send in WhatsApp to me or to Vaibhav. His number is available on the website, also in director section. And one detailed presentation on Hindu Succession Act is available on our YouTube channel, and that is available free of cost to everyone. If you go through it, you will also learn many things in addition to this syllabus. It is very important slide and a very important presentation, and everyone need to understand the Succession Act as applicable in India. So Vaibhav, Mr. Vaibhav, thank you very much for sparing your valuable time during your examination period also. Highly grateful to you. Goodbye. Good luck.
Thank you, sir.
Thank you, Mr. Vaibhav.
Thank you. Thank you.
Thank you, sir.
So friends,
Thank you, sir.
Thank you, Engineer Vaibhav Pansalji. So we will continue with our topic which we were discussing before the break. So next topic, as far as syllabus is concerned, is Transfer of Property Act 1882. So this act basically governs the legislations that governs the transfer of property in India. So basically, you know, whenever you are buying a property, what does this mean? It means you are buying a bundle of rights. So whenever you are buying a bundle of rights, then how the transfer is to be done from the property, transfer of property from one person to another person. How it is to be done. So it governs the transfer of property in India. It is a comprehensive legislation. So it defines the rights and responsibilities of the parties, that those who are involved in the transaction and the transfer of property, and it ensures that transactions are conducted fairly and legally. So what are the key features of this act? But first of all, you must understand the term, what is transfer? So whenever you are doing valuation, first thing you have to check whether the property is transferable or not. So before that, you must understand the term, what does this term transfer means? So according to the section 5 of the Transfer of Property Act, transfer of property is when a living person conveys property to one or more living persons. When the property is transferred from one living person to one or more living persons, or to himself and one or more other living person, either presently or in the future. So the term living person means it also includes companies. So must understand that it does not mean that only human being comes under the term living
Mr.
person.
Venkata, Mr. Venkata, here is the answer of your question. You have typed in the chat box. Here is the answer of your question. Yes, sir. Please continue, sir.
So a living person includes companies, associations, and body of individuals. So the transfer must take place when the property is in existence. First thing is property must exist. So for example, a person selling the house to another individual is an example of transfer of property. So when you sell a property to another person, it means you have transferred a property. And a company or an association of persons, association of companies, they can also transfer the property from one person to another. So now we will discuss who are the persons who are competent to transfer. So everyone is not a competent. Who is competent to transfer? First thing is only those who, so basically transfer of property also comes as it is a form of contract. So if a person is competent to contract, he is also competent to transfer the property. So only those who are competent to contract can transfer the property. Remember this thing. So for example, an adult with sound mind can sell their property, but minors are persons of unsound mind. As they cannot enter into a contract, they can also not sell a property. A minor cannot sell a property. A person of unsound mind cannot sell a property. Next is oral transfer. So section 9, it deals with the oral transfer. Oral transfer of property is valid if it is movable. Remember this term, movable. If the property is movable, then the oral transfer is valid. As example, handing over the car to someone with written agreement is valid if both the parties agree. So conditions of restraining alienation. Section 10, it mandates the conditions that restraints absolute transfer of properties are void. For example, a condition in a will that prevents the heir from selling the inherited property is void. If someone has made a will in favor of his, let us suppose, in son, but it is written there that he cannot sell that property, it will be termed as void. Then rule against perpetuity. Certain interest in the property are void if they are to take effect after the expiration of certain period. For example, a trust that attempts to control the use of property for more than 21 years after the death of the person creating the trust is void. So after a certain period of time, if the trust does not take the control within 21 years, then if he take it after 21 years after the death of the person who has created a trust, it will be treated as void. Then transfer of benefit of unborn persons. The persons who are still not born. So property can be transferred by the benefit of unborn persons provided the interest vest within 21 years of transfer. For example, a person cannot transfer the property to their unborn grandchild with the interest vesting within 21 years. Then rights and liability of buyers and sellers. What are the rights and liabilities of buyers and sellers? The section 55, it gives the rights and liabilities of the buyers and sellers. All these things are clearly mentioned in this section 55. It includes the buyer's right and it includes the seller's right, seller's liabilities, buyer's liability. All these things are given in section 55. For example, a buyer can inspect the property. It is his right before purchasing the property and can claim damages if hidden defects are found. If the person does not mention that there is, if it was known to the seller and he does not mention it to the buyer about the hidden defects, then the buyer can claim damages. So transfer of immovable property. So, for example, a person selling their land to another individual must follow the procedure which is outlined in the Act, including drafting a proper sale deed and registering it with the appropriate authority. So, in case of immovable property, it has to be registered with the competent authority, with the sub-registrar or registrar as the case may be. So, but immovable, it is important for immovable property. In case of movable property, it can be done orally as we have already discussed, but it is advisable to have a written agreement to avoid disputes in future. Then transfer to unborn persons. So a parent setting up a trust for their unborn grandchild, ensuring their interest vest within 1 years, complies with the Act's provisions. Then sale. Sale is defined under section 54 of the Act. It defines the definition. It means transfer of ownership of the property in exchange for price paid or promised. So it may be paid at the time of transfer or it may be promised after a certain period of time. So it is paid or promised. For example, a person sells their house for 50 lakh. The ownership is transferred to the person on payment of rupees 50 lakh. Then mortgage. Mortgage is defined under section 58 of the Transfer of Property Act. So in case of sale, all the interests are transferred to the buyer. But in case of lease, only certain interests which are mentioned in the lease deed are transferred to the lessee. Not all the interests. See the difference between them. When you transfer a property outright sale, it means all the interests, whatever interest the seller was having, all these will be transferred to the buyer. But in case of lease, only those rights which are mentioned in the lease deed are transferred to the buyer. Lessee, not all the.
Friends,
So
it is a very important concept to be learned. Very important concept. यहाँ पर हम maximum गलतियां करते हैं. Yes, sir. Please continue.
So transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced by way of loan. A homeowner mortgages their property to a bank to secure a loan. The bank has the right to sell the property if the loan is not repaid. Then gift is done under section 122. So main thing is you have to remember the sections. So gift, definition of gift is transfer of property made voluntarily without consideration. See here, it is without consideration. Means no payment is to be done in gift by one person to another person. So in selling, you have to make payment. The only difference is in case of gift, there will not be any consideration. So a person gift their house to their child, no money is exchanged, and the child accept the property. The thing is that the person to whom the gift is given, he must accept the gift. That is the important thing. Donee must accept the gift. Then exchange. So exchange is done under section 118. It is transfer of ownership of one property for another property. See here, it is not for a price paid. It is exchange of property for one property to another property. So Mr. A gives his property to Mr. B, and Mr. B transfer another property to Mr. A in exchange of the property which was given by Mr. A. So the two landowners exchange their plots of land, benefit from better location for size of their respective areas for respective uses. Then assignment. So what does this assignment mean? The transfer of rights of interest in property from one person to another person. So for example, a landlord assigned their right to receive rent from a tenant to another person. So that is assignment. So see the difference. This is, and then charge. Charge is under section 100. So what is definition of charge? An interest or lien created on the property by the owner for securing the payment of money. For example, a person takes a loan from the bank and bank creates a charge on their property as security. The bank has a right to recover the loan amount from the property. So it means they have created a lien or a charge on the property. That if the loan is not repaid, they have the right to sell the property and recover their loan amount. So they have the right to recover the loan amount from the property. Then lien, the right to retain possession of the property until a debt owed by the property owner is discharged. That is lien. So see the difference between charge and lien. Charge means an interest created. That is the loan is not repaid. The person who has given the loan, he has the right to sell the property and recover the loan from the property. And lien is the right to retain the possession of the property until debt owed by the property owner is discharged. For example, a mechanic repairs a car and retains the possession of the vehicle until the owner pays the repair services. Then tenancies and subtenancies. The lease property for a specified period in return for rent. For example, a tenant leasing a residential apartment decides to sublet a room to another person. The subtenant pays the rent to the tenant, who in turn pays to the landlord. So this is especially done in case of lease. If it is a tenancy under Rent Control Act, in the Rent Control Act, tenant is not allowed to have subtenant. But in lease deed, if there is lease deed and if it is written in the lease deed that lessee can have sublessee, only then it is possible. So remember, if the property is under tenancy, under Rent Control Act, their subletting is not allowed. But under lease deed, sublease, see, you can have sublessee. Lessee can have subless. He can sublet the property. Then lease of immovable property, it is done under section 105. A transfer of right to enjoy immovable property for a certain period of time in return for a price paid or promised. For example, a company leases an office space for 5 years, agree to pay rent to the property owner. So practical examples, now we can take certain practical example. For example, sale. If homeowners sell their flat in Mumbai for rupees 1 crore, the buyer pays the amount and the ownership is transferred through a registered sale deed.
Friends, with these examples, you will be able to learn the difference between all these terms. These are very, very important examples given in a very simplified manner. Yes, sir. Please continue.
Then is mortgage. A business owner mortgages their warehouse to the bank to secure a loan of 50 lakh. If the loan is not repaid, the bank can sell the mortgage to recover warehouse to recover the money. So that is mortgage. Gift. An uncle gifts his farm to his nephew. No money is exchanged and the nephew accepts the gift, gaining of ownership of the farm. Exchange. Two farmers exchange their fields, which are of equal value, to better align with their agricultural need. Assignment. A property owner assigns their right to collect rent from the tenants to a friend as repayment for a loan. Charge. A person creates a charge on their property in favor of a bank to score a loan for starting a business. Lane. A jeweler repairs a necklace and retains the possession of it until the customer pays for the repairs.
देखिए, अगर आप अपनी कोई भी चीज किसी को रिपेयर करने के लिए या अगर मेंटेनेंस करने के लिए देते हैं तो वो उसके पास लीन पर रहती है, मींस ही हैज टू रिटर्न इट टू यू. अगर आप अपना कोई भी कपड़ा सिलवाने के लिए दर्जी को देते हैं तो वो भी एक लीन. अगर आप अपना कोट सिलवाने के लिए आप किसी टेलर को देते हैं, दैट इज आल्सो लीन. आप अपनी मोटरसाइकिल रिपेयर कराने के लिए किसी रिपेयर शॉप को देते हैं, दैट इज आल्सो लीन. Yes, sir. Please continue.
So next, tenancies and subtenancy. A tenant leasing a shop sublets part of the space to another business. The subtenant pays rent to the tenant who continues to pay the original landlord. Then lease of immovable property. A company leases a commercial property for 10 years, agreeing to pay an annual rent to the property owner. So lease granted by private bodies and statutory bodies can have different impacts on the property valuation due to distinct objectives and regulatory framework governing each type of lease. So whenever you are doing valuation, you have to check lease by private bodies. That is an important. Private bodies typically lease properties for commercial purposes, aiming to maximize profit. The valuation of such properties is influenced by market demand, location, and potential income generated from the lease. For example, a shopping mall owned by a private company is leased to various retail stores. The valuation of mall will be based on its location, foot traffic, and rental income it generates. Then lease by statutory bodies. See here how the valuation is to be done. If the valuation, if the lease is done by a private body, we have tried to explain it with an example of a mall. But if it is done by a statutory body, for example, as local authorities lease properties often for a public welfare or societal purpose, the valuation of the properties may consider factors like social impact, community benefit, and regulatory guidance. For example, a government-owned building leased to a non-profit organization for community services. The valuation might be lower than the market rates due to social value provided by the lease. Then, what is the impact on valuation? If the property is given by the government statutory bodies on lease for social purposes. So first thing you have to consider market value versus social value. So private leases are usually valued at market rates, while the statutory leases may be valued lower due to their social purpose. Then regulatory guidance. Statutory leases may be subject to specific regulations that affect their valuation, such as rent control laws. Then income potential. So in case of private leases, they are often valued based upon potential income, whereas statutory leases might be considered broader social or economical benefits. Then in your syllabus, you have to learn certain sections. We will discuss them one by one. One is Section 3 Interpretation Clause. So it provides the definition for various terms which are used in the Act, this Section 3. For example, it defines the immovable property. So various things which are there in this Act are defined under Section 3. It is also called Interpretation Clause. Such as immovable property, it defines what is immovable property. It defines immovable property as land, benefits arising out of the land, and things which are attached to the earth. So immovable property is that land or benefits arising out of the land are the things which are attached to the earth. Then Section 5, it defines the transfer of the property. So it defines the transfer of property as an act by which a living person conveys the property to one or more living persons, or to himself and one or more other living persons. For example, a owner selling his house to another individual considered a transfer of property. Then Section 6, it defines what may be transferred. What may or may not be transferred. So it is what may be transferred, it is defined in Section 6. It lists the kinds of properties that may be transferred. Property of any kind may be transferred except those mentioned, like a mere right to sue public office, etc. So you cannot sell a
myth कि अगर मशीनरी है तो वो मूवेबल प्रॉपर्टी होगी. नो, जैसे सेक्शन 3 में बताया गया है, इफ इट इज अटैच टू द ग्राउंड और उसको हटाने के लिए कोई चीज डिसमेंटल करना पड़ेगा, वेदर फाउंडेशन हटाना पड़ेगा या कोई दरवाजा बड़ा करना पड़ेगा या कुछ और हटाना पड़ेगा, देन इट कम्स अंडर द इमूवेबल प्रॉपर्टी डेफिनेशन. तो अगर मशीनरी है और आप सोचते हैं ये मूवेबल है हमेशा, इट इज नॉट द करेक्ट वर्ड. Machinery can also be an immovable property if it is attached to the ground in such a manner that it cannot be dislocated without dismantling the civil structure. Then it comes under the immovable category.
सर एक्चुअली जैसे राइस मिल हो गई तो वो भी क्या इमूवेबल प्रॉपर्टी हो गई?
सर राइस मिल एक अलग चीज है, एक मशीनरी की मैं बात कर रहा हूँ. राइस मिल तो अपनी जगह पर ही होगी, वो तो इमूवेबल प्रॉपर्टी में ही मानी जाएगी.
राइस मिल में जो मशीनरी जो होती है मैं उनकी बात कर रहा हूँ.
किसकी सर?
राइस मिल में जो मशीनरी जो होती है.
हाँ, जो मशीनरी अगर एम्बेडेड टू ग्राउंड है और उसको हटाने के लिए आपको कोई ना कोई डिसमेंटल करना पड़ता है तो वो इमूवेबल मानी जाएगी. जैसे अभी आप फार्मास्यूटिकल यूनिट में आप देखिए, कुछ मशीनरी ऐसी होती है जो बहुत बड़ी होती है, काफी बड़ी होती है. तो जब वो मशीनरी इंस्टॉल होती है तो उस वक्त बिल्डिंग तब तक पूरी नहीं बनाई जाती. पहले उस मशीनरी को अंदर किया जाता है, अंदर सेट करने के बाद उसको डोर्स एंड विंडोज लगाए जाते हैं. तो जब डोर्स एंड विंडोज लग गए और मशीनरी वहां पर इंस्टॉल हो गई, तो उसके बाद अगर उस मशीनरी को कभी वहां से डिसलोकेट करना है तो वो पूरा का पूरा सिविल स्ट्रक्चर को डिसमेंटल करना पड़ेगा, क्योंकि उस दरवाजे से वो बाहर नहीं निकलेगी. तो वो इमूवेबल प्रॉपर्टी में काउंट हो. There are various acts and case laws related to these few words. Yes, sir.
हाँ जी बंसल जी.
Yes, sir.
हेलो. हाँ जी.
बोले सर.
वन क्लैरिफिकेशन प्लीज बंसल जी.
Yes, sir.
हाँ जी, जैसे अपनी इलेक्ट्रिक लिफ्ट है वो भी फिक्स है, वो सिविल का पार्ट गिना जाएगा इमूवेबल का?
सर सिविल का पार्ट नहीं गिना जाएगा, लेकिन इमूवेबल प्रॉपर्टी गिनी जाएगी अगर वो लैंड के
अच्छा
अंदर
ऐसे।
फिक्स है और उसको हिलाने के
हाँ।
लिए आपको कोई ना कोई डिसमेंटल करना पड़ता है कोई भी स्ट्रक्चर, तो वो इमूवेबल माना
अच्छा,
जाएगा।
जनरेटर लाइंग ऑन द रूफ टेरेस पे है,
नो, वो तो मूवेबल है सर,
मूवेबल है, हाँ।
वो मूवेबल।
इलेक्ट्रिक पैनल है, किसी बिल्डिंग में 30-35 इलेक्ट्रिक पैनल है मॉडर्न,
पैनल भी
दैट इज
मूवेबल है
फिक्स
सर,
इन।
पैनल भी मूवेबल है। कुछ मशीनरी है जो फाउंडेशन के बिना नहीं इंस्टॉल हो सकती, कुछ ऐसी चीजें हैं जो जो हटाने के लिए, जैसे बहुत बड़ा बॉयलर है तो बॉयलर को आप ऐसे ही रख के ऐसे उठाकर नहीं कर सकते, उसके लिए पूरा इंस्टॉलेशन आपको करनी पड़ेगी। वो इंस्टॉलेशन रिमूव करने के लिए अगर आपको उसको डिसलोकेट करना है, कोई चीज हिलानी है, तो उसके लिए आपको कुछ ना कुछ चीज तोड़नी फोड़नी पड़ेगी। अगर वहां पर कोई तोड़ना फोड़ना पड़ता है, देन इट इज कॉल्ड रिमूवेबल। यस सर, राजविंदर सर प्लीज कंटिन्यू।
Yes, sir. Thank you, Sandeep. Next is Section 7. We have already discussed. It defines persons who are competent to transfer. This is defined in Section 7. So we have already discussed that all those persons who are competent to enter into a contract, they are also competent to transfer. So next is conditional transfer. So it defines the conditions on which property may be transferred. This is under Section 25. A property owner transfer the land to another on the condition that the recipient must marry within 2 years. So if the recipient fails to marry within period, the transfer becomes void. So this is just an example that it may be valid only certain thing is done by the person to it is transferred. Then Section 53, it defines fraudulent transfer. So transfer made with the intent to defeat or delay the creditors of this transferor are considered fraudulent. For example, a person transfer his property to a friend to avoid paying creditors. The transfer can be declared as void by the court. So the person, let us suppose person A was has taken some loan from Mr. B, but before paying the property, he has mortgaged his property to Mr. B, but during this period, he has not repaid the loan, but he transferred the property to Mr. C. So this transfer will be considered as void. Then part performance. This is defined in Section 53A. So let us suppose
यस सर, एक मिनट के लिए देखिए, ऐसा एक केस मैं आपको प्रैक्टिकल बताता हूँ। एक रजिस्ट्री आई, रजिस्ट्री के बाद आपके पास वैल्यूएशन के लिए आई, वैल्यूएशन आपने कर दे दिया। उसमें था कि एक प्रॉपर्टी परचेज की है मिस्टर ए ने मिस्टर बी से, और मिस्टर बी को एक चेक दिया है एक अमाउंट का। उसके बाद में वो रजिस्ट्री बैंक में देता है, बैंक में देने के बाद प्लेज करने उसको मॉर्गेज करने के लिए देता है। लेकिन प्रॉब्लम क्या हुआ, वो चेक जो उसको दिया था वो चेक डिसऑनर हो गया, इंटेंशनली और अनइंटेंशनली डिसऑनर हो गया। तो थोड़ी देर के बाद रेवेन्यू डिपार्टमेंट ने या गवर्नमेंट ने उस रजिस्ट्री को इनवैलिड कर दिया। तो इस केस में वैल्यूअर इंटीग्रिटी कम ऑन स्टेक। तो इस तरह के ये पढ़ाने का पर्पस आपको ये है कि आपको ये चीजें पता होनी चाहिए कि अगर आप ट्रांसफर और प्रॉपर्टी एक्ट में क्या क्या चीजें जरूरी हैं और उसको कंसिडरेशन उसको मिल चुका है या नहीं मिल चुका है। अगर कंसिडरेशन मिल चुका है तभी वो वैलिड होगा, नहीं तो वो उसके बाद में अगर कंसिडरेशन का चेक उसमें डिसऑनर हो गया है या नहीं लगाया गया है, किसी वजह से नहीं हुआ है, देन दैट ट्रांजेक्शन विल बी नल एंड वॉइड। ये आपको पता होना चाहिए। यस सर, प्लीज कंटिन्यू।
Then Section 53A, part payment. So let us suppose Mr. A has sold his property to Mr. B. Mr. B has made all the payment and has taken the possession of the property. But Mr. A fails to get the property registered in favor of Mr. B. Even then, Mr. B will be considered as owner of that property. So if a buyer has paid the part of the purchase price and taken possession of the property, but the sale deed is not registered, but they can still claim possession under this section, section 53A. Then next is Muslim personal law. So Muslim personal law governs the aspects of as Hindu personal law has been very clearly explained to you by engineer Web. So now we will discuss about the Muslim personal law. Muslim personal law governs various aspects of Muslims' life, including marriage, divorce, inheritance, and family relations. It derives the authorities from the Quran, Hadith, and various Islamic juristic interpretations. According to this law, certain relatives have fixed shares in an inheritance. It is not as according to the Hindu inheritance law. Here, certain relatives have fixed share. For example, the wife is entitled to 1/8 share in the property if there are children, and 1/4 if there are no children. See here, wife is entitled to 1/8 if in the property if there are children, and if there is no children, he is have 1/4 right in the property as per this Mohammedan Muslim personal law. For example, if a man dies and leaves behind a wife and 2 children, the wife receives 1/8 of the estate, and the remaining is distributed among the children. Means remaining 7/8 will be divided among the children. Then residuary. After allocating the fixed share, the remaining estate goes to the residuary heirs, usually male relative like sons, brothers, or uncles. For example, if a man leaves behind a son and no fixed share of heirs, the son inherits the entire estate as a residuary. Then daughters and sons. Daughters and sons receives half the shares of the daughter receives half the shares of the sons. For example, if an estate is divided between a son and daughters, the son gets 2/3 and the daughter gets 1/3. And marriage and divorce, as per this act, marriage in Islam is a contract between two consenting parties. For example, a man and a woman agree to marry with the man providing a meher to the woman, establishing their marriage contract. Then talaq, the process of divorce initiated by the husband. A husband pronounces talaq 3 times leading to the end of the marriage. There are specific rules and waiting periods to follow. Then divorce by wife. A woman can seek divorce through khulla by returning the meher or part of it to her husband. A wife, if he is unhappy with in her marriage, offers to return the dowry to obtain a divorce, and the husband agrees. Then mutual consent. Both parties can mutually agree to end their marriage. Both husband and wife decided to part ways amicably and agree to divorce terms. For example, inheritance. We will take some example. A man with 3 children, 2 sons and 1 daughter passes away. The estate is divided with each son getting 2/5 and daughter getting 1/5. For example, a Muslim couple, as far as an example for marriage, a Muslim couple decides to marry, agreeing a meher of 50,000. The marriage contract is signed and they are now married under Muslim personal law. And then divorce. A husband pronounces talaq once entering a waiting period. If reconciliation occurs within this period, divorce does not take effect. If not, the process may continue until it becomes irrevocable. So Muslim personal law ensures that various aspects of Muslims' life are governed according to religious principles, providing a clear framework of personal and familial matters. Then, as far as Hindu Succession Act is concerned, we need not to go in details. We, as engineer Weber Bansal has very clearly explained to you each and every concept of this act. So these are the things which are important for real estate laws. So now we will take certain case laws which are important from examination point of view. Many times you get questions. There are 10 important case laws which are in your syllabus, from where you always get questions related to these important case laws. These are very important. So as far as syllabus is concerned, you have to learn important case laws on principle of valuation of real estate. First one is R.C. Cooper versus Union of India.
Friend, these are very, very important case laws in your syllabus as well as for practical life. Sometimes during a valuation or during some litigation, you may ask, you may be comfortable to quote these case laws to defend your valuation report as well as yourself also. So it is very important to understand that different case laws are related to real estate valuation, and these case laws are of 2% weightage in your examination also. 2 questions will certainly come, and ये बिल्कुल simple questions हैं और ये आपको 2 मार्क आपको लेने ही हैं. बहुत सिंपल क्वेश्चन आपसे पूछा जाता है, वो भी राजविंदर सर अभी बिल्कुल आपको बताने लगे हैं, and it is very easy to get these 2 marks during your examination, as well as very important for quoting different citations during your practical visits, and somewhere if you face any type of difficulty during litigation or any other court case. Yes, sir. Please continue, sir.
So as far as syllabus is concerned, from IBBI examination point of view, first one is R.C. Cooper versus Union of India, and second is Saurabh D. Talati versus Joseph Mecom. Third one is CWT versus P.N. Sakan. Next is Wenger and Company versus DVO. Fifth one is Jawalaji Naganathan versus Revenue Divisional Officer. Next is Chimanlal Hargovindas versus SLAO. Next is CED versus Radha Devi Chalan. Next is CIT versus Ashima Sinha. Next is CIT versus Anupam Kumar and others. And the last one is CIT versus Vimla Ben Bhagwan Das Vatai. So it is having a weightage of 2%, means at least you will get a 2 marks question out of it. So there will be 2 type of questions. One will be that certain paragraph will be given to you or certain things will be given to you, and you have to answer that from which this statement has been taken. Certain statement will be given to you and you have to name the case name. You have to give the name of the case. Or name of the case will be given, and you have to provide the details which are given in this case. So it is very easy. In the end, we will try to explain that how you have to remember these case laws. We will try to learn these things also. First case law is R.C. Cooper versus Union of India. It is very important case law. It was in this case, that Supreme Court has explained the word property. So what does it means as far as property is concerned from legal point of view? So property means highest right a man can have to anything. Highest right a man can have to anything, being the right which one has to lands or tenements, goods or chattels, which does not depend on another's courtesy. So this is important thing. You have to remember this thing. Highest right a man can have. So property means highest right a man can have. So whenever you see this word highest right, it means it has been taken from R.C. Cooper versus Union of India. Or if it is R.C. Cooper versus Union of India, it means you have to tell that it gives the definition of property, means the highest right a person can have.
Friends, for examination purpose, you need to remember few keywords which will reflect the name of the case or name of the case with related to few keywords for easy remembering purposes. Yes, sir.
It includes ownership of estates and interest in corporeal things, and also rights such as trademarks, copyrights, patents, and even rights in personam capable of transfer or transmission such as debts, and signifies a beneficial right to a thing considered or having money value, especially with reference to transfer or succession and to their capacity of being injured. Then the court has included all types of properties, including intangible and tangible assets are included in this. And most important thing in this case is that this gives bank nationalization. So you know bank nationalization was done, and bank nationalization in view of socialism or priority allocation of other resources, it was done under this act. So it is a landmark judgment. It was given by a 11 judge bench. Remember. So it constitutional validity of bank nationalization by Indira Gandhi government was challenged under this in this case. So nationalizations to be invalid as by a majority of 10:1 observed that nationalization of banks impaired the right of compensation under Article 31, subsection 2 of the Constitution of India, and consequently was struck down after primarily on the ground of violation of Article 31, subsection 2. So in this case, SC has struck down the nationalization of banks, which was done by the Indira Gandhi government. But after the pronouncement of this judgment, then bank companies acquisition and transfer of undertaking act 1970 was enacted by the parliament, but with the inclusion of a specific amount of compensation to be paid to each of the 14 banks. So before that nationalization of banks was announced, it was challenged under this act and under this case law, and it was struck down by the Supreme Court with a majority of 10 judges in favor of striking it, and only 1 judge was opposing it. And because of it, then the government has to enact a new act in the parliament, which was called Acquisition and Transfer of Undertaking Act 1970, to validate the nationalization of banking. And but then in this act, it was included that specific amount of compensation was to be paid to the 14 banks which was nationalized at that time. And the next case is Saurabh D. Talati versus Joseph Meckham. It is appeal number 101 of 1949. In 1949, a small causes court of Bombay for the first time laid down the principles of rent fixation. So standard rent, which we have been discussing so far, it was first of all brought in by the small causes court of Bombay. So basically it gives the investment theory of rent, which we have already know. So standard rent was first of all discussed by, in this case, in the case of Saurabh Talati. So whenever there is anything related with the investment theory or comparable rent theory or standard rent, so it all deals with Saurabh D. Talati. So what it says that, first of all, it gives the calculation of standard rent on the basis of investment theory of rent as compared to, instead of comparable rent theory. To fix standard rent of rent controlled properties, the court considered return or yield from the gift as security as the basis for determining the fair rent to the landlord on his investment in land and building. So basically what was done at the first time, that gilt as securities was considered as a basis. Gilt as securities are that securities, that bonds, that government bonds, which are in which you are sure to get at least the return mentioned in the bonds. Let us suppose if a government bond says that it will give you 6% return, it means you are sure to get that 6% return. That is gilt as security. So what this case law says, that it will be considered as the base for calculation of standard rent, and for land, owner will get 1.5% higher than the gilt as security, and for the building it will have 2.5% higher than the gilt as security. Let us suppose the gilt as security is providing you 6% return. It means for land you will consider 7.5% return, and for the building you will consider 8.5% return for calculation of standard rent. This was how the standard rent was fixed as far as this case is concerned. And for leasehold properties, what the court says, in leasehold property, 1% extra yield on both type investment is to be considered. Because in case of yield year, you will be calculating the value on the basis of return. So higher the rate of return, lower will be the value. So in case of leasehold property, you will be, for land, it will be 2.5% higher than gilt as security and 3.5% higher than gilt as security. Means for land, it will be 8.5% and for building, it will be 9.5% return, on which you will be calculating capitalized value of the property.
देखिए, आपको कभी कभी रेंट फिक्सेशन के लिए बैंक बोल सकता है, या फिर आप रेंट कंट्रोल एक्ट के अंडर कोर्ट की तरफ से आपको कभी कोई इस तरह का केस मिल सकता है। तो अगर आप कोई परसेंटेज कोट करते हैं तो आपको अपने आप को डिफेंड करने के लिए याद होना चाहिए सौरभ डी तलाती वर्सेस जोसेफ मैकम। ये केस आपको कोट करना है और इसका रेफरेंस लेकर आप अपनी वैल्यूएशन रिपोर्ट बना सकते हैं, और यू कैन इजीली कोट दीज जजमेंट्स in your valuation report, how and why you have considered that particular percentage for calculating the return on that particular property. Yes, sir.
Next is CVT versus PN Sakan. It is also an important case law. The hold of leasehold interest on the condition that if he assigns 50% of unearned increase in the value of the land will be payable to the lessor. So court held that assessee determining the value of leasehold interest of the assessee in the land for the purpose of assessment of wealth tax, the price of which the leasehold interest would fetch in the open market would have to be reduced by 50% of the unearned increase in the value of the land as it's a hypothetical sale on the valuation. For example, value was calculated by the approved value as 1,82,268, and unearned increase, we have done one question, what is unearned increase? And unearned increase was 1,30,000. So the court has accepted the value, 50% of the value is to be deducted. So gross annual rent is 1,32,000, net annual rent is 82,956, YP is 10. So the value comes out to be 8,29,560. It is reduced to 6 lakh since this figure was accepted by the wealth tax officer. So
And it is also a
basically,
very important case for leasehold properties. If a property is on lease, तो आपको ओनर्स इंटरेस्ट निकालने के लिए अनअर्न इंक्रीज निकालना पड़ेगा. अनअर्न इंक्रीज अगर आप देते हैं तो आप कैसे कैलकुलेट करेंगे, और उसके ऊपर अगर कभी आपको अपने आप को डिफेंड करने के लिए कोई जजमेंट देना पड़ा तो यू कैन वेरी इजीली कोट CWT वर्सेस PN सिकंद 1977 का केस है. 107 नंबर है, ITR 922 सुप्रीम कोर्ट ऑफ इंडिया प्रॉपर्टीज के ऊपर. यस सर, मिस्टर पुरी, यू वांट टू कोट?
सर मेरी ये रिक्वेस्ट है, सॉरी इंटरप्ट कर रहा हूँ. एक्चुअली जितनी लीज होल्ड प्रॉपर्टीज है उसकी लीज टर्म्स ही डिफाइन करेगी कि भाई अनअर्न्ड इंक्रीज अगर मेंशन है तभी उसको कम करेंगे, अगर नहीं मेंशन तो नहीं करते आप.
नहीं वो तो है ही सर.
हाँ जी. एक सर हम जो कर रहे हैं इन प्रैक्टिकलिटी 90% 99% वैल्यूज आर डिक्रीज कम नहीं कर रहे लैंड एंड बिल्डिंग के, और हम जब कम करते हैं तो बैंक श्योर हो जाता है कि आपने फेयर मार्केट वैल्यू से कम की. तो हम उसको क्या करते हैं, जो द लास्ट जो हम देते हैं जो 75% देते हैं, जिसमें डिस्ट्रेस बोलते हैं, उस पर बोलते हैं, वाटर रेट, उस पर नहीं जाते क्योंकि बैंक उस पर लोन नहीं करता. तो फिर ये एक सेविंग फेस हो जाता है कि चलो बैंक का भी हमने भी कम कर दी, बैंक भी खुश हो गया और हमारा काम भी चल गया, हमें कोई ऑब्जेक्शन नहीं कर सकता.
लेकिन इट इज बेटर टू मेंशन एट द एंड ऑफ द रिपोर्ट के कंक्लूजन में आप जरूर मेंशन करिए कि आप ये क्यों कर रहे हैं और किस लिए कर रहे हैं, सो दैट इन केस अगर कोई लिटिगेशन होता है या कोई चैलेंज होता है तो एटलीस्ट आप कोट कर सकें, सर देखिए मैंने तो लिखा हुआ है यहाँ पर और ये सही है, और उसी के कंसिडर करके ही मैंने प्रॉपर्टी को इसको डाउन किया है या प्लस किया है. तो अगर आप वो मेंशन करेंगे तो अपने आप को डिफेंड करना एट द टाइम आपको, कि जब वो पता नहीं 2 साल के बाद आएगा, 3 साल के बाद आएगा, 5 साल के बाद कोर्ट में केस होगा, तब तक आप भूल चुके होंगे मैंने क्या किया था. तो अगर आप उसको वैल्यूएशन रिपोर्ट के अंदर इनकॉर्पोरेट कर देंगे, आप उसके नीचे कंक्लूजन में कहीं ना कहीं मेंशन कर देंगे कि बेसिस ऑफ कैलकुलेशन आपकी क्या है, तो हमेशा इजी रहेगा. नो डाउट आप अपने ऑफिस में रिकॉर्ड तो जरूर रखिए उसका, लेकिन वैल्यूएशन में भी उसको ब्लैक एंड व्हाइट में लेकर आइए.
वैल्यूएशन में हम बकायदा कैलकुलेशन मेंशन करके उसको वैल्यू को कम करते हैं.
बिल्कुल बिल्कुल सर.
एक सर वो इससे पहले जो हम डिस्कस कर रहे थे, जो गिल्ट एज जो हम सिक्योरिटी की बात करें उसको PLR ले लें, लाइन लैंडिंग रेट जो बैंक्स का चलता है.
तो वो भी ले सकते हैं, प्राइम लैंडिंग रेट भी ले सकते हैं, लेकिन जो कोर्ट ने लिखा वो गिल्ट एज सिक्योरिटी ही लिखा है वर्ड.
तो ये हम गूगल कर लिया.
बेसिकली जब आप पंजाब, वैसे हर स्टेट का जो रेंट कंट्रोल एक्ट है उसमें अलग से प्रोसीजर दिया गया है. अगर आप पंजाब का देखोगे तो उसमें उन्होंने 10% लिखा है, यहाँ पे तो परसेंटेज लिखी है ना, गिल्ट एज सिक्योरिटी का बेस माना गया है इसमें. लेकिन पंजाब में कुछ ऐसा नहीं लिखा. पंजाब रेंट कंट्रोल एक्ट में 10% डायरेक्ट ही लिखा है, लैंड एंड बिल्डिंग दोनों के लिए. हर एक स्टेट के लिए डिफरेंट है सारी बेसिकली.
तो मकान में जाके देख ले, पंजाब मकान में.
जी सर.
थैंक यू सर, सो नाइस ऑफ यू.
थैंक यू सर. And next one is Wenger and Company, DVO versus Wenger and Company versus DVO. So district welfare officer adopted two methods to value the property. So what he done for the owner occupied portion, it was done on the basis of prevalent market rates, and for the tenanted portion, it was done on the basis of capitalization of rental value. So what this case says that if a property, a certain portion is occupied by the owner and a certain portion is given on the rent, then for the owner occupied portion, you have to use market value of the property, calculate the value on the basis of market, prevalent market rates. And for the tenanted portion, you have to do its value on the basis of income approach, means capitalization of rental income. So both the methods have to be adopted in case the property is tenanted as well as owner occupied portion. Next is Jivaji Nagnathan versus Revenue Divisional Officer. So this is important from land acquisition point of view cases. So in case of Jivaji Nagnathan, the court said the basic valuation registered, prepared and maintained for the purpose of collecting stamp duty has no statutory base or force. It cannot form a foundation to determine the market value mentioned under in the instrument brought for registration. Evidence of bona fide sales between willing prudent vendor and prudent vendee of the land acquired is situated near or about that land possessing same or similar advantageous features would furnish the basis to determine the market value.
देखिए, बहुत इंपॉर्टेंट केस है. अगर आपको कभी बैंक की तरफ से चैलेंज आता है कि आपने रेवेन्यू रेट के हिसाब से प्रॉपर्टी इतना बनता है और आपने इसका वैल्यू इतना दिया है, तो वहां पर अगर आपको अपने आप को डिफेंड करने के लिए कोर्ट कभी कोई करना पड़े, तो ये केस कोर्ट करिए, जिवाजी नागनाथन वर्सेस रेवेन्यू आरडीओ, रेवेन्यू डिविजनल ऑफिसर. इसमें क्या कहता है? इट कैन नॉट फॉर्म अ फाउंडेशन और डिटरमिन द मार्केट वैल्यू मेंशन्ड देयर अंडर इन इंस्ट्रूमेंटेड. It is therefore clear that the basic valuation register prepared for maintaining the purpose of collecting stamp duty has no statutory base or force. Clear यहाँ पर मेंशन किया हुआ है. अगर कभी कोई बैंक आपको बोलता है कि एट द टाइम ऑफ एनपीए कि आपने यहाँ पर 1 लाख रुपए पर यूनिट आपको रेट था और आपने इसको 3 लाख रुपए पर यूनिट लगाया है एज पर मार्केट, तो ये आपने गलत किया है और आपको चैलेंज कर सकता है. तो आप उसको अपने आप को डिफेंड करने के लिए ये केस आप उनको दिखा सकते हैं. नो डाउट आपकी इंटीग्रिटी और ऑनेस्टी वहां पर जरूर होनी चाहिए एट द टाइम ऑफ प्रोवाइडिंग दैट वैल्यूएशन. लेकिन अपने आप को डिफेंड करने के लिए आप ये यहाँ पर दिखा सकते हैं कि सिर्फ स्टैंप ड्यूटी आप वैल्यूएशन के लिए नहीं मान सकते. दैट इज नॉट द बेस. और ये कोर्ट ने इसका डिसीजन दिया हुआ है इन जिवाजी नागनाथन वर्सेस रेवेन्यू डिविजनल ऑफिसर इन 1994. इट इज वेरी इंपॉर्टेंट केस लॉ. यस सर, प्लीज कंटिन्यू सर.
Next is Chimanlal Hargobind Das versus SLAO. So as per this case law, the court has given decision that the following factors must be taken into account while doing the valuation. Instances whenever you are doing valuation on the basis of market approach, what the court says. So it is an important thing when you are doing valuation on market approach. The instances which you have to take into account, only those can be taken if they are very proximate, means very near in the vicinity of the property of which you are doing valuation. And second thing, they are genuine. The instances which you are taking into consideration, they are very proximate to the property of which you are doing valuation. They must be genuine, and the acquisition itself has not motivated the purchaser to pay higher price on account of resultant improvement in the development prospects and the location. These 4 factors have to be considered for determining the.
जब आप कोट करते हैं कोई भी वैल्यूएशन, तो उसमें बोलते हैं मैंने ये वहां से प्रॉपर्टी डीलर से पता किया था 4 लाख रुपीस पर स्क्वायर यूनिट है. तो वो आपको कैसे आप अपने आप को डिफेंड करेंगे? तो यहाँ पर बिल्कुल क्लियर चिमनलाल हरगोविंद दास वर्सेस SLAO पुणे 1988, इट इज वेरी मच क्लियरली डिसाइडेड बाय द कोर्ट कि जो भी आप वहां पर आप सेल इंस्टेंसेस देंगे या जो भी आप कोट करेंगे, एंड दैट एज पर लॉ यू हैव टू कीप द रिकॉर्ड फॉर मिनिमम फॉर 3 years फॉर इंस्पेक्शन पर्पसेस एंड अदर्स. जब भी आपका कोई इंस्पेक्शन होगा या फिर कोई कोर्ट की तरफ से होगा या फिर कोई अथॉरिटी की तरफ से होगा, स्टैट्यूटरी इंस्पेक्शन होगा, तो आपको ये प्रोड्यूस करना पड़ेगा कि आपने ये सेल इंस्टेंसेस कैसे लिए. Why not only 1 lakh rupees? Why not 99,999 and why not 1,10,000? तो उस वक्त आपको ये देखना पड़ेगा, नंबर वन, they are very proximate, they are genuine, and they are itself not motivated with the purchase to pay a higher price or account of the resultant improvement in development aspects and location. ये चार चीजें आपको उस वक्त आपको अपने आप को डिफेंड करने के लिए आपको अपने पास रखनी ही पड़ेगी कि अगर मैंने कोई पर यूनिट रेट कोट किया है तो उसका क्या बेस है. The following factors must be taken into account while doing a valuation. Very important case law. Chimanlal Hargovindas versus SLAO. Yes, sir.
So some of the important factors which you must consider as per this case law. So positive factors, if the value, if you are doing valuation of a property which is smaller in size, of which you have taken certain comparable, if your property is smaller in size, it will be considered as a positive factor. If it is larger in size, it will be considered as a negative factor. And if it is nearer to the main road, it will be considered as a positive factor. If it is situated in the interior at a distance from the road, it will be considered as a negative factor.
You have learned these factors in sale comparison method. तो आपको अपने आप को डिफेंड करने के लिए ये केस लॉ हमेशा टिप्स पर होना चाहिए कि मैं इसके पॉजिटिव फैक्टर मार्केट अप्रोच के हिसाब से मैं स्मॉलर साइज का मैं ज्यादा रेट लगा रहा हूं और बड़े साइज का मैं कम रेट लगा रहा हूं. तो आपको पता होना चाहिए कि मैं अपने आप को डिफेंड करने के लिए कल को अगर मुझे डिफेंड करना पड़े तो मैं ये केस कोट कर सकता हूं. प्रॉक्सिमिटी ऑफ रोड, रोड के पास है, रोड से दूर है, तो रोड के पास का मैं रेट थोड़ा ज्यादा लगा रहा हूं, रोड से दूर का मैं रेट कम लगा रहा हूं. क्यों लगा रहा हूं? दैट इज वेरी मच clearly defined in this case law. Yes, sir. Please continue, sir.
Then frontage on road. If your subject property is having more frontage on the road, it will be considered as a positive factor. And if it is a narrow strip of land with very small frontage as compared to its depth, it will be considered as a negative factor. And there you may have to apply belting method also. Then level versus land under acquisition. With land under acquisition. So if it is having a property, subject property is at the road level, and if it is lower than and it requires it is having depresses and earth filling is to be done, it is be considered as a negative factor. And if it is nearer to the developed area, it will be considered as a positive factor. And if it is remoteness from the developed locality, it will be considered as a negative factor. Then special value for an owner of an adjoining property to whom it may have some very special advantage. And some special disadvantage factors which would deter the purchaser, it will be considered as a negative factor. So the evaluation of these factors, of course, depends upon the factor of each case. There cannot be any hard and fast or rigid rule as per the court, and common sense is the best and the most reliable guide as far as this case law is concerned. For instance, take the factor regarding the size. Firstly, while a smaller plot is within the reach of many, a large block of land will have to be developed. By preparing a layout means you have to calculate the value of a developed or a large chunk of land on the basis of development potential and which we have already done. Development method of valuation. A large chunk of land will be divided into certain plots, smaller plots. Then you will deduct the area for roads and other amenities. Then you will deduct the cost of constructing roads and other amenities. And then you will decide the per unit price of smaller plot. You can apply discounting, which we have already done, that how the discounting is to be done. You may have higher positive discounting or negative discounting, ranging from 5% to 50%, depending upon the case may be. So next case is
Sir, I think you are on mute.
There is no voice.
the next case is CED versus Radha Devi Jalan. So it is a similar case. It says that rented properties has to be valued by rent capitalization method. And in case of buildings which are in the possession of tenants and the tenants cannot be evicted or rent payable them cannot be enhanced except in accordance with the provisions of Rent Act, only appropriate method of valuation is to be do valuation with capitalization of annual rent by certain number of years purchase. So the method of valuing land and this building separately and adding them to calculate the value will be improper in such cases, and it would ignore the impact of Rent Control Act on the value of the land and building.
देखिए बिल्कुल क्लियर किया गया है इस केस लॉ में, सीडी वर्सेस राधा देवी जलान 1968 का केस है, बिल्कुल क्लियर किया गया है। आप जब भी विजिट करने जाते हैं आप कुछ नहीं देखते कि रेंट पर है या नहीं है, लीज पर है या नहीं है, सीधा लैंड एंड बिल्डिंग लगाते हैं। लैंड इतना मल्टीप्लाई बाय लैंड का एरिया मल्टीप्लाई बाय रेट, लैंड का वैल्यू, बिल्डिंग का कवर्ड एरिया मल्टीप्लाई बाय बिल्डिंग का रिप्लेसमेंट रेट और उसके बाद डेप्रिसिएशन लगा के सीधा वैल्यू दे देते हैं। यहां पर इस केस में बिल्कुल क्लियर किया गया, द मेथड ऑफ वैल्यूइंग द लैंड एंड बिल्डिंग सेपरेटली एंड एंडिंग अप द वैल्यू वुड बी इम्प्रॉपर इन सच केसेस। अगर आपने कोई वैल्यूएशन दिया है और वो एनपीए हो जाता है या वो लिटिगेशन में आता है या उसको चैलेंज किया जाता है, देन यू विल बी इन ट्रबल बिकॉज यू कैन नॉट कोट दिस केस लॉ इन योर वैल्यूएशन रिपोर्ट। तो आपको, अगर आपने लैंड एंड बिल्डिंग के ऊपर किसी भी रेंटेड प्रॉपर्टी का वैल्यूएशन दिया है तो आप इस केस लॉ के अंडर, इस डिसीजन के ऊपर यू विल बिकम culprit or you have to face the litigation challenges in the court. Yes sir, please continue.
So next case law is CIT versus Ashima Sina. This court case law says that valuation officer, the valuation of land is taken twice, which the amount included in the yield method and again under the reversionary method. So if the property is affected by Rent Control Act, when you calculate the value of the property, it includes the value of the land also. You cannot take the reversionary value of the property because the land will never be reverted back to the landowner. So the court says if the property is under Rent Control Act, you cannot add the reversionary value of the land. So this is an important case. Means under rent, you can take the reversionary value of the land only in case if the Rent Control Act is not applicable. If the Rent Control Act is applicable, you cannot take the reversionary value of the land. So it will add up twice, it says. Means आपने 2 बार land की value add कर. So you can take the reversionary value of the land only in case if the property is not affected by Rent Control Act. So it is given in CIT versus Ashima Sin. Next case law is CIT versus Anupam Kapoor and others. So it is similar case in which the valuation officer has taken the reversionary value of the land in calculating the value of the property, and it says that you cannot take twice the value of the land. When you calculate the value of the property by rent capitalization by applying appropriate years purchase, it includes the value of the land and structure. So in this case, the Calcutta court rejected the concept of reversionary value of the land. The above case was fully tenanted property and obviously therefore land reversion was not possible and hence its value cannot be added. And next one is CIT versus Bimla Van Bhagwan Das Patel. So it gives the details that how you can assume the rate of capitalization. The rate of capitalization should not be unreal and must have some due regards to the commercial rate of returns after taking into consideration the various constraints and insecurities in the property market. After considering payment provisions, the court opined, in our opinion, the reasonable and appropriate rate of capitalization would be 8.33 times the net average annual income, which would give yield of 12% per annum on the investment of capital investment. So they have given the rate of return in case of properties which are under rent capitalization, Rent Control Act as 12%, which will give you a YP of 8.33. 100 upon 12, it will be 8.33. So it was given by the court that you can use 12% rate of return in case of rent controlled rent properties affected by Rent Control Act. So in the end, we will be discussing certain key points which will enable you to remember these things. The
first one, very, very important table prepared by CEV and Dr. Arvinder sir. इसके अंदर आपको की वर्ड्स हैं जो याद रखने हैं और रिलेटेड केस लॉ आपको दिया गया है. आप अगर इसको अच्छी तरह से याद रखेंगे, एटलीस्ट फॉर एग्जामिनेशन पर्पस आपको काफी हेल्प मिलने वाली है. एज वेल एज इन द प्रैक्टिकल लाइफ ऑल्सो, अगर आप ये टेबल को प्रिंट निकालकर आप अपनी टेबल पर रखेंगे, इसको इस प्रेजेंटेशन का प्रिंट निकाल कर 2 पेज हैं, इसका प्रिंट निकालकर अगर आप अपनी टेबल पर रखेंगे, कभी भी आपको केस लॉ आउट करना है और रिलेटेड आपको कहीं भी डाउट आता है तो आप इस केस लॉ को रेफर कर सकते हैं. ये इंटरनेट पर भी अवेलेबल है, सीवी की वेबसाइट पर भी अवेलेबल है, एज वेल एज इन डिटेल आप इसको हाई कोर्ट या सुप्रीम कोर्ट की साइट पर भी जाकर देख सकते हैं. यस सर.
So first one was, it was Rustam C. Cooper versus Union of India. So nationalization of banks.
ये आपको किसी भी बुक में नहीं मिलेगा, ये टेबल आपको किसी भी बुक में नहीं मिलेगा. यस सर.
So if you see any word such as nationalization of banks, definition of property, tangible or intangible assets, or 25th Amendment of the Constitution, it means it is related with Rustam C. Cooper versus Union of India. If you see the words honor occupied by sales comparison method and tenanted property by rent capitalization method, it means it has been taken from Wenger and Company. And if you see the guilt as security, word guilt as security as a basis for determining the fair return on the landlord or his investment, then it means it has been taken from Saurabh D. Talati versus Joseph Mekam. If you see the word unearned increase, 50% unearned increase, it means it has been taken from CWD versus PN Sakan. And if you see the basic valuation registered or stamp duty statutory base as in force. It means it has been taken from Jivaji Naganathan versus Revenue Divisional Officer. Or if you see the word evidence of bona fide sales between willing prudent vendor and prudent vendee of the land acquired are situated near or about the land possessing same or similar advantageous feature would furnish basis for to determine the market value. It means it has been taken from Jivaji Naganathan versus Revenue Divisional Officer. And if you see the word that code drives plus and minus factors to be considered for land acquisition, comparison of instances plays major roles in arriving at the value. It means it has been taken from Chimanlal Hargovindas versus SLA. And if it says properties under rent capitalization method and investment in rent shall be considered as in accordance with the provisions of Rent Control Act, it means it has been taken from CE VRSO versus Radha Davi Jalan. And in the case of CIT versus Ashima, the court has said that the value of the land cannot be taken twice in case of rent controlled properties, means reversion of the properties cannot be taken. Reversion of land cannot be taken in case of rent controlled properties. Similarly, reversionary value of the land cannot be taken if the nature of the tenancy is of perpetual nature. It was in the CTR versus Anupam Kapoor and others. And in case of Bimla by Bhagwan Das, the court has given the procedure for or how to assume the rent rate of capitalization. It was given by the court in CIT versus Bimla Das Bhagwan Das, Bimla Ben Bhagwan Das case.
देखिए इनकम अप्रोच से कभी भी आप रेंटेड या टेनेंटेड प्रॉपर्टी की वैल्यू करते हो, रेट ऑफ कैपिटलाइजेशन लेट इट भी आपको एज अ वैल्यूअर आपको फील्ड में एसेस अपने आप खुद ही करना पड़ता है, खुद ही अज्यूम करना पड़ता है। तो अपने आप को डिफेंड करने के लिए, रेफरेंसेस लेने के लिए आप हमेशा विमला बहन भगवान दास पटेल, ये केस बहुत इंपॉर्टेंट है, 1979 का केस है, गुजरात का केस है, गुजरात हाई कोर्ट का, और ये आप इसको कोट कर सकते हैं अपने आप को जस्टिफाई करने के लिए कि आपने ये रेट ऑफ कैपिटलाइजेशन आपने इतना ही क्यों लिया है। Yes, sir. Please cut.
So these are the certain case laws which you may have to learn. So another presentation is on the website of our CEV. You can refer for further details. I will show this. Yes, hold on.
The detail of all the case laws as well as related questions are also given in your folder for study material. It is very well explained in that each and every case law is explained in detail, including the decision taken by the Honorable Court, as well as the keywords, as well as the related questions which used to appear during the examination are also added in that folder. Yes, sir.
Another presentation is there on the website, which you can say go through. In this certain other laws which has not been discussed because of paucity of time and to complete the syllabus, which are beyond the syllabus, we are also included in this presentation. Certain acts. First thing, you must understand what is the importance of real estate laws in valuation. So they are important for calculating the accurate valuation of the properties and for a risk assessment and enforceability of laws. And then Transfer of Property Act you have understood, learned, but there are certain other acts which are related with Transfer of Property Act. One is Registration Act 1908. It is again important from Transfer of Property Act. It is related with Transfer of Property Act because the property has to be registered, and it has to be registered under Registration Act 1908. And it says that all those properties which are having values greater than 100 has to be registered. If it is an immovable property, it is mandatory registration. And in case of lease, which is below 1 year, or instruments acknowledging receipt of dowry, wills, or instruments not requiring mandatory registration, for them under Section 18, you may have optional registration. And then if the property is not registered, then what will be its effect? That the documents cannot affect the property, cannot be produced as evidence for transaction if the property is not registered, and may still be used as a collateral evidence. Then next is Indian Stamp Act 1908. You must remember, learn this act as a value, though it is not in your syllabus, but it is an important act from valuation point of view. So means if you have to check if the property buyer has paid adequate stamp duty at the time of registration, and if it has not been done, it cannot be treated as an evidence in a court of law. It can be treated as in the court of law as an evidence only when the deficiency in the stamp duty has been paid with penalty. You have to remember this. If evidentiary value will be only if full stamp duty has been paid. If it has not been paid, see here, insufficiently stamped documents cannot be admitted as evidence in court proceedings unless deficiency is rectified. This significantly impacts the enforceability and consequently affect the security of title in the valuation. So many times we do not go through this concept, but remember, it is only valid if sufficient stamp duty has been paid. It cannot be considered as an evidence. It does not have any evidentiary value in the court of law if the proper stamp duty has not been paid. So then this Land Acquisition Act you have already gone through. See here how the first this act was of 1884, now 1894. Now the act has been revised, and because of this, the acquisition has increased manifold. If the value and compensation was given by older act of 1894, see the difference. Urban residential property, if you were getting less than 15,000 compensation, now it will get higher than 30,000. Similarly, urban commercial property, which may get 15,000 and compensation, now it can get 50, 45, 3 times the property compensation. Similarly, rural agricultural property may get much higher compensation. So see here, this thing you have to remember. In case market value is multiplied by 2 times in urban areas and 4 times in rural areas, plus 100% solution is given. See the compensation which is given, you must remember this thing.
This can be asked in your MCQ also.
So you may go through this presentation, which it is